Non-appears is been dismissed on 1/9/2005. Lordship, my prayer, small prayer. Lordship, may restore and dispose of granting liberty if cause of action arise.
Take it also. The court is not satisfied with the explanation of the application is dismissed.
Item number 2.
May I please, Your Lordship? My lord, the present petitioner before Your Lordship is the president and along with the other villagers and of the respective village committee, my lord, they are appearing before Your Lordship filing this PIL petition to protect the geographical boundaries of their village Paikrapur, which is the mother village, by whom there is a deduction of land, huge amount of land that is from the mother village, that is festival land, gochara and field cultivated land along with village temple. And my lord, from that mother village there is making of hamlet village to revenue village, my lord. My lord, as per the 2021, the OP number 1 circulated a circular to make huge number of hamlet village into revenue village. There is certain criteria, and fulfilling certain criteria, the hamlet village converted into revenue village. But my lord, here in this case, the hamlet village, which is going to be a revenue village, which is not even a ward, not fulfilling any of the among criteria. And my lord, for the said fact, the petitioner here in this case earlier approached its honorable court in WPC number 3967 of 2023, in which there is a direction to OP number 4 to redress the grievance of the villagers, mother village Paikrapur. But my lord, the OP number 4 only appeared for 7 minutes and without listening the grievance of the villagers.
Earlier it was before a single judge.
That was before the single judge.
And now how come this is before?
Because it is in the form of PL, there some private individual has filed.
Same person filed.
Same persons.
Same Hemant Kumar Bhatta only filed.
Yes, madam.
How come that is single judge and this is?
My lord, the single bench that is for the grievance of the petitioner due to the BCP case, border changing proceeding. But my lord, here in this case, due to the grievance is not ultimately redressed, the OP number 5 influence.
Same matter, madam. This is the second round with the same person, same Hemant Kumar Bhatta.
But the grievance is not redressed. The present petitioners.
No, because grievance is not redressed, it should become a PIL. Suddenly, overnight, it will become PIL. It will go to the division bench. How is that possible? That order was passed in
Lord,
That was the direction of this honorable single.
No, that was order passed in February.
My lord.
No.
My lord.
And that order has not been complied with, according to you.
My lord.
But why didn't you file a contempt?
My lord, the OP number 4 appeared the redress is like that. He appeared but not listening the villagers. That's why it is needs highly public interest, my lord. The law and order situation is going to arise between among the villagers, because the
no. This is not an answer to saying how come suddenly you can file a fresh petition calling it a PIL. The same cause of action, same grievance. Single judge has passed an order in your favor. According to you, that order has not been complied with.
My lord.
And you are now again, by just labeling it as a PIL, you now want to bring it before a division bench.
My lord, that is complied, but that is not proper.
You yourself are saying it's not complied.
My lord,
you are saying he listened to you, not only 3 minutes. So how is it compliance?
That is compliant.
You yourself are saying it is not compliant.
I admitted that.
That is your case, that it has not been complied. For non-compliance, what is the remedy? Non-compliance remedy is not that you again file a fresh PIL for the same matter. Counsel to the petitioner seeks leave to withdraw the present petition, will liberty to seek other appropriate remedies as may be available to the petitioner according to law. Disposed of is withdrawn, liberty is paid for.
Item number 3.
None appears dismissed.
Item number 4.
Item number 4 millet, 2014 matter millet, I couldn't pressure on a file millet. It was such a limitation petition is there. My search from the
counsel to the petitioner states the file is not traceable. But dismissed for non-prosecution with liberty to seek restoration in case the file is traced.
Item number 5.
None appears dismissed.
Item number 6.
None appears dismissed.
Item number 7.
None appears dismissed.
Item number 8,
Same order.
item 9,
Same order.
item number 10,
Infractions, my lord, are not pressed.
Dismissed as infraction.
item 11,
None appears dismissed.
item number 12, item number 12,
None appears dismissed.
item number 13,
All of his name.
item 13, Dr. Sunil Kumar Ratha, the petitioner.
None appears dismissed.
Item number 14,
May I please have wishes? Sure. More than half an acre of land in the outskirts of the Bhubaneswar has been encroached by the opposite part number 4, and the land has been reserved for Pani Nala, your lordship, as a water body. I have made a representation. My representation is at page 17 and 18, your lordship.
Where is
And-
the acknowledgement?
Acknowledgement is at page 30, your lordship. Lordship, accordingly, RI report was called for. The RI report is at page 31, your lordship. It fortifies my stand that the plots have been encroached by the private person for encroachment of for construction of road, your lordship. However, no steps has been taken.
Notice that he accepts notice on behalf of 1, 2, and 3. Notice to respond to 4. Returnable. Ninth August.
Much obliged.
item number 15,
But the petitioner is the Sarpanch of Dengbahal, and sole grievance of the petitioner is that the primary agriculture cooperative society is going to be established at Denkipalli, which is not convenient for the villagers, for which
Alright.
he has
The
filed a
petitioner's
representation
representation
paper.
shall be considered. The petitioner's representation bracket annexure 3 shall be examined by the collector Balangir and after notice to the petitioner and giving him a hearing. A reasoned order should be passed not later than 14th August 2023 and be communicated to the petitioner within a week thereafter. Board clarifies it is not expressed in the matter.
item 16,
May I please. Here, my lord, the petitioners are tribal people of village Tonto, my lord. They are challenging the conversion of forest land for the setup of a industry, my lord. Now, my grounds of challenge is, my lord, the Gram Sabha which has been called for that total result has been manipulated. Further, my lord, the interest of the forest land has been protected under Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Act 2006, my lord, which says, my lord, this forest land cannot be converted for the purpose of industry, my lord. Section 3 may I read, my lord, for
We can put an NGT for this, sir.
my lord.
This is a matter for the NGT Pollution Control Board.
No, Pollution Control Board, my lord, after approval of from Gram Sabha, that has been referred to the Pollution Control Board for their clearance, my lord.
Anyway, if you say it should not be correct, you say illegal conversion.
Yes, my lord. Illegal, my lord, because under the statute, my lord, may I place this section, relevant section, my lord, for what,
You made a representation.
my lord, I made a representation before the collector,
My lord, he has not included the beneficiary company as a party.
Oh,
That
he
is
is not.
Messrs. Narveram Steel and Power.
How
Limited.
come you not made them a party? You are seeking relief against them, sir.
Yes.
I will
The-
make party, my lord. I will implead party. Permission, maybe,
We don't need permission. You have to seek permission, in fact.
my lord. Here, my lord, the statute says there is no provision for conversion of the land for the purpose of setting of industry, my lord. Only for the purpose of schools, dispensary, hospital, Anganwadi, fair price shops.
In your representation, have you mentioned? Yeah, just see that representation.
My lord.
Subject matter, you've actually mentioned the company.
Illegal settlement of land in favor of MS Navaram Steel and Power.
We'll ask him to issue notice. You say the petitioner's representation, bracket annexations, shall be examined by the collector.
Yes, because
Kionjar.
my lord, one thing is that conversion order itself is appellable.
Conversion.
That order is appellable. But still, if your lordship will direct the collector being as an appellate authority, he can also examine.
After notice to the petitioners. And
Petitioner and the beneficiary.
Narberam Steel and Power Limited. And after giving them a hearing, the reasoned order shall be passed not later than 14th August and be communicated to the parties within a week thereafter.
May I pray another
Clarifies that is not expressed anywhere.
My lord, may I pray, my lord, because the 25th it has been posted for environmental clearance, my lord.
All right, you just say
That may
be
be
open to the petitioner to seek appropriate interim orders for the collector.
obvious.
Item number 17. Item 17.
Hannah, please dismiss.
Item number 18.
Item 18, my lord, 3 days time be granted for filing of the requisites.
Sorry?
3 days time be granted for filing of requisites.
Issue fresh notice, sir. Requisites have not been filed. Fresh notice as a last chance. Fresh notice returnable. Well acceptable.
Item 19.
In item 19, my lord, on last occasion, the lordship has directed me to take instruction. So no instruction, your lordship may give me last chance. I have received the instruction seeking some more time.
More time is taught by Mr. Puntia. Learned AGF instructions. That's the last chance. List again, 12 September. All right.
Item number 20.
Sorted kindly.
Item 20.
At last occasion, your lordship wanted to know what would be the financial implication. I have taken instruction that it will be around 10 lakhs, my lords. Here, what happened, my lords? The MOU was signed between company and the BPUT on 31st July 2013, covering from 1/8/2012 to 31/7/2013, my lords. The incident took place on 23/7/22. Prior to entering into MOU, the accident took place, and thereafter he was operated after the policy MOU was granted.
All right, you say notice returnable. September. There shall be a stay of the impugned order till then.
Okay. Item 21.
Well, the first matter I'm appearing in 21. Giving a short note, this the first matter is covered by an order of the Honorable Supreme Court. From the note itself, I will demonstrate, as well as the Honorable Single Judge has also taken note of that aspect. Lordship, I have given that. I have seen that order of Honorable Single Judge and the order of the State Administrative Tribunal is covered by that
judgment of this court.
Yes, ma'am. Yes. So far as the first matter is concerned, it is squarely covered by the judgment of Aparna Sinha. I have given a short note.
He's also saying the same.
Yes. So that's the first matter. But so far as other matters, your lordships have to examine because the other points are.
Yes, ma'am. I am submitting. Your lordship may see.
890 of 2022. It is not in dispute that the present petition appeal stands squarely covered in favor of the respondent by the judgment dated 7th September 2020 passed by this court in writ petition civil 10616 of 2020. That is the matter. The present appeal shall stand disposed of in terms of said judgment. And the same relief is granted. It will be noted here that the SLP filed against the above judgment dated 7/9/2020 by the state of Orissa being SLP Civil 195-196 of 2021 was dismissed by the Supreme Court of India on 20th January 2021. So all these 6 appeals.
No, let me.
No.
Lordship, see that I am giving the numbers, my lord.
890, 967, 1028, 1093, 1097, 1158.
All the numbers.
Covered, my lord. 1158 is covered.
I am. Lordship, see, in that case, covered is WA number 1028 of 2022 and 109 of 2022, 1096 of 2022, and 1097 of 2022, and 1158 of 2022. These matters are covered, but subject to one condition that I have given that cut-off mark. So, and in that memo, I have given that cut-off mark. Those who have come within that cut-off mark, their case can be considered.
No, my lords. Here, my lords, I would say, my lords, cut-off mark, even Aparna Sinha had got below the cut-off mark.
No, my lord. So they cannot be covered, my lord. In Aparna Sinha, your lordship may see the Honorable High Court's order, my lord.
Main already.
No, at that point of law is not decided, my lord.
No, in the first read, it is decided. The Honorable Single Judge has clearly said that.
No, in Aparna Sinha, your lordship may see I have given that Aparna Sinha's judgment,
My lord, Aparna Sinha main judgment is a tribunal judgment, my lord.
Tribunal. Thereafter, Honorable High Court, your lordship said page 12 of my memo.
Yes.
Your lordship may see that I am reading from page 13.
Yes.
On verification of record, it appears that a new additional merit list name of the opposite partner appears at serial number 60 and in total he secured 220.67 marks in the merit list. It is submitted by Mr. Mahapath that no candidate securing less marks than the petition has been appointed. He, however, submits that there is a vacancy and the opposite party number 1 can be appointed accordingly. In that view of the matter, this court, without going into the details of the submission made by the learned counsel for the party, direct that opposite party number 1 be appointed in the post of contractual hand register pursuant to government words. So that I have given that list, my lord, your lordship, in my memo. Page 16, my lord.
Yes.
This is the cut-off mark. And the next, my lord, page 17. Is the mark secured by the respondents in different writ appeals, my lord. And next page, my lord, page 18, there is a vacancy position.
Right.
So unless they secure more than the last cut-off mark, so they cannot be appointed, my lord.
Vacancy is there, my lord.
He's not disputing that.
My lord.
I am not disputing that. I have given that vacancy position unless.
Sir, my lord, may kindly see page number, page 115 of writ appeal number 890 of 2022.
That's over, sir. 890, we have already.
All is covered, my lord.
Just, sir, so far as if they raise this issue of cut-off mark now, then so far as my client, I must fairly say that she has got below the cut-off mark.
No. They are not raising it for 890.
No,
890 is over.
No, in all cases, I am raising that point.
Oh.
Unless they secure more mark than the last cut-off mark, they cannot be appointed.
In that case, Aparna Sinha, she has got appointment, she has got below the cut-off mark. That's what the Honorable Single Judge records. So that's what I wanted to show, my lords, page 115 of the writ appeal. Cut-off mark. So at page, my lord, may kindly see page 115, entry number 66. That is Aparna Sinha, where her cut-off mark is 223.9214. And the cut-off marks which they have fixed is 225.9612. And so far as the present respondent is concerned, her marks would be as per the formula reflected would be 223.473. That is at page 111. So she's at the same footing as Aparna Sinha. Aparna Sinha, they have appointed even though she got below the cutoff marks, and that has been approved by the Honorable Supreme Court.
Yes.
And the Honorable Single Judge in the impugned judgment takes note of this development at paragraphs 19 and 20.
What happens if somebody gets some 10 marks then?
No, my lord, this cutoff.
No, I'm just saying, where will you draw the line? You're saying even below the cutoff mark, you still get appointed.
My lords.
Suppose somebody gets some 50 marks, then what happens?
Now, my lords, for them to get over this, they have to say, we are not on negative equality. Aparna Sinha was the same.
No, I'm asking you. Suppose another person, this person got also some 2 marks less or 3 marks less than the cutoff mark.
My lords.
What if somebody gets 100 marks below the cutoff mark then?
My lords, then the question would be that where do they draw the line?
Exactly. That's what we are asking you. You say no line can be drawn. You're saying because Aparna Sinha also got less than the cutoff mark and Aparna Sinha was appointed, all of us should be appointed even though we got less than the cutoff mark. This is your argument.
My lord, we are claiming equality vis-a-vis Aparna Sinha.
Yeah, correct. So you're saying equality means if she has got less than the cutoff mark, I have got less than the cutoff mark, we can't be discriminated.
My lord.
I'm asking, suppose you have got 10 marks. Aparna Sinha got 2 marks less than the cutoff mark. You get 100 marks less than the cutoff mark. No difference, according to you?
My lord, in view of that, there's no difference. But here, my lords, may I submit?
We'll examine this. We'll examine this.
The other question which calls for consideration would be, for 1 minute, my lords, may I just submit? So far as the cutoff marks issue that they are raising, that the Honorable Single Judge has categorically held that the issue of there was no cutoff mark fixed earlier.
So we'll have to decide this. According to you, even if you get 5 marks and Aparna Sinha got some 220 marks, both 5 and 220 is less than the cutoff mark.
This is not a case where it's that very.
No, we have to examine case.
No, both case. The marks are a part of.
Suddenly you may decide, sir, if it is only 100 marks, I also concede it's not equal. If it is 200 marks, you'll say, no, it is equal.
Here it's a question of 0.5%, 0.5.
We don't know. Individually, see, this has to be decided on principle. According to you, the principle is, irrespective of how much mark I have got, as long as Aparna Sinha got it because it was less than the cutoff mark, if mine is also less than the cutoff mark, I get it. This is your principle. You have to test it.
May I please, Lordship, kindly permit me. Lordship, kindly see main judgment of the Aparna Sinha before the tribunal at internal page 10.
We'll examine all of it, sir.
My Lordship, examine one moment. You Lordship, kindly permit me.
Sure.
Page 10, internal page of the tribunal judgment. Everything mentioned. May I read internal page 10 of the tribunal judgment, that is OA number 1090 of 2016.
Yes.
Internal page 10, my lord.
Yes.
So the stand of the respondents, may I read?
Yes.
So the stand of the respondent in the counter that BA qualification is must for appointment is not tenable if a candidate has got the qualification of Shastri from Odisha Rashtrabhasha Parishad, then he has the minimum eligible qualification for the post. Therefore, on the ground that the applicant has no BA qualification is not tenable. Besides, this applicant has also shown that she has acquired +3 arts from Utkal University in 1996 as Annexure 10. So the candidature of the applicant cannot be rejected. Our candidature has been rejected even though we have passed BA.
I am not disputing that.
Please. So the candidature of the applicant cannot be rejected. Besides this, after the corrigendum on 6/1/15 Annexure 6, the relevant extract para 8(2) has already been quoted where it is mentioned that in case a candidate possessed more than one qualifying examination, the examination in which she has secured highest marks will be considered while preparing the merit list. Citing this, applicant had made representation to the authority and accordingly additional merit list has been published wherein the name of the applicant finds plate a serial number 66 Annex 8, wherein she has secured so and so marks. She belongs to your female category. And the last candidate, important, last candidate, your female category appointed has secured 188.0320.
So you've got this Aparna Sinha got more than 188.
Yes. We have also got more than some can
all the similar candidates
used to saying that Aparna Sinha got less than the cutoff.
Yes, my yes. Your Lordship, the chart I have given that cutoff mark. That has been wrongly stated. That I have given the chart. Your Lordship, see what are the last cutoff mark.
Neither taken the point before the tribunal or before Honorable Single Judge or Appeals Court.
Your Lordship, see
yes.
That page is
16.
Well,
So 225.
Yes, my lord, your lordship, you are untrained 225. You are women 227.2818.
So they're all UR category.
Yes, now some are UR, some are SCBC. Your lord, so 180. Your lordship, there is your lordship, you are untrained women 227.2818.
Anyway, you respond to it. You
Yes.
say, Mr. Kuntia raises before the court a compilation which includes the category-wise single quotes last candidate's career assessment score selected for Hindi teacher in the year 2014-15. He therefore argues that although the respondents would be covered by the order passed or judgment dated 7 September 2020, passed with the division bench of the Court in Writ Petition Civil 10616 of 2020, the respondents can be granted the same benefit provided they have scored more marks than the last qualified candidate. Paragraph. This is seriously contested. He is also enclosed, sorry, full stop. He is also enclosed in his compilation. The set scores of the last selected candidates in the various categories. Paragraph. The above submission is seriously contested by counsel appearing for learned senior counsel appearing for the respondents. Full stop. According to them, Aparna Sinha herself had got less than the cutoff mark and was yet given the appointment, whereas all the respondents herein, having got less than the cutoff mark, are being denied such benefit. Paragraph.
Some candidate may have got a higher than cutoff mark.
It is further pointed out some of the respondents have higher than the cutoff mark. Full stop. A copy of the compilation be provided to counsel for the respondents within 3 days.
I am giving just now.
It will be open to the individual respondents to prepare their respective notes of submissions on the basis of the above note handed over today by Mr. Kuntia. List on 28th August.
And your lordship, there is a number WF557 of 2022. This is different, your lordship, fixed to another date.
It has been fixed to 18th of September, your
18th
lordship.
of September.
557, you say list on 18th September.
Or if your lordship can take it as a lead case, it can also be disposed of, your lordship. A very simple question of law is involved.
So the 18th September.
18th September.
Except my lord 557, all those cases.
Correct.
Yes.
I have served copy my compilation.
Right.
We are grateful. The second item, my sub item, 18th of September, your lordship. Second sub item, 18th of September.
18th September.
Item 22.
Reading item 22, the copy of that judgment, my lord, I will provide after getting that sector copy I have applied. Let it come after vacation, my lord, I will provide this.
All right.
22 next day.
See, at the request of counsel for the appellate list on 31st August.
Item number 23.
23, my lord, the office has pointed out some deficit in the requisites. I will file in course of the day, my lord.
What is the matter about?
Here, matter, my lord, the single judge. Here, present in writ appeal, the petitioner is a bank. There is a award in the arbitration under the Cooperative Society Act. And
we just say requisites is not filed. As a last opportunity, fresh notice to respondent returnable. 27 September.
Obligation.
Item number 24.
Rejoinder counter was served on 8th. We have sent the rejoinder for waiting. 1 week, 10 days.
Whenever filed before the next date. List on 27 September.
Interim order to continue.
Interim order to continue.
All the 3 matters, 24,
right.
25, 26.
All right.
Grateful.
Item 27.
None appears dismissed.
My lord, there are some defects. 1 week time may kindly given for remove the defects.
What's that, sir? 22 matter.
My lord,
What's the matter about?
matter. My senior will argue.
Should we pass it over?
My lord.
All right, pass it.
Item 28.
Nana, please.
Item 29.
May I please, Your Worship? This matter officer pointed some defects, lordship for me to remove the defect, or I'll place.
Yes, please.
The Annexure 3, page 69, the order passed by the Honorable Single Judge is under challenge, lordship. The matter relates to violation of reservation in APP examination, lordship. Lordship, Annex 1, page 34, lordship, kindly have a glance for a moment. This is the advertisement issued by the OPAC regarding appointment of APP, where the total post was a lordship 46, out of which a lordship page 34 in subcategory last portion, lordship, there is persons with disability, 4 seat was reserved, out of which low vision 2 and locomotor disability including leprosy cured and rapids and acid attack victims 2, lordship. Then, lordship, I invite lordship, as per the advertisement petition, the present appellant applied for the post and selected in the first merit list, call for document verification, and the final result was published in page 54, lordship, kindly see. Page 54 of the brief, final result was published, where the result is at page 55, where in serial number 40, only 1 locomotor disability have been given, and entire 46.
Have you applied in that category, sir?
My lord.
Please come to para 12.
Para 12 the order, lords. My lord. Yes, lords.
Kindly read it, sir.
The heard the counsel for the parties, fair with the material available on record, this court, after going through the same, find that the petitioner made his application as a SC male category with the subcategory person with disability. In view of the clarification issued by the government of Orissa in General Administration and Public Grievance Department dated 19/121, coupled with the decision of the Honorable Appeals Court rendered in the case of Saurav Yadav and others supra, this court finds that no illegality has been committed by commission in not recommending the case of the petitioner as against the subcategory persons with disability. This is the view of the Honorable Single Judge LRC, but which is against the decision in Mohesh Kumar case LRC, Mohesh Gupta and others, reported in LRC 2007-8 Supreme Court, cases 621 LRC, where in para 11. Para 12 of that judgment, lordship, disability has drawn the attention of the worldwide community. India is a signatory to various international treaties and conventions. The state, therefore, took a policy decision to have horizontal reservation with a view to fulfill its constitutional object as also its commitments to the international community. A disabled is a disabled. The question of making any further reservation on the basis of caste, creed, or religion originally may not arise. They constitute a special class. This is the observation of the Honorable Appeals Court in Mohesh Gupta case. Here the specific reservation in the advertisement is so far the locomotor. But in locomotor category, if there is no other reserve category, that cannot be reserved for the general people. Here, though the present petitioner is a locomotor category placed in the merit list, call for verification, he is an eligible candidate as for the selection lordship on merit. But only due to there is no reservation for locomobility in the male category, he has been brought to get the job lordship, which is clearly discrimination in the eye of law, lordship.
It's a notice returnable. 18 September.
Item number 30.
Oblige, your lordship.
14th of September, my lord.
All right.
The work charge applied. Item 31.
For 2 and 3, I am appearing.
None appears to the petitioner. Dismissal.
32.
Oh, you are there. 1 minute. Are you Mr. Chakradhar Sahu?
Yes, sir.
32, sir.
Just, he's in that earlier matters.
Item 30.
Kindly excuse us. He's in the earlier matter.
Item 31.
Yes, sir. Kindly proceed.
Sir, my point is, I am a retired employee. My officer has held me in a paper under whom I was working. That's why I am applying for a revaluation of answer paper. It is clarified in while dispatching the review petition of 49, 2009, the Honorable Court had issued some directions at 4I and 4II.
Yes.
Thereafter, I applied to the department, but they have rejected my application. That's why I'm applying for a revaluation order issued from court. So the direction may be issued
Why is
from
it a
court
division
to
bench
the
matter? It's
department.
an appeal. Is it writ appeal? What's the order of the single judge, sir? Let's see. You have said you're withdrawing the petition.
I said I have submitted my petition to the department. As a
No, to the single judge. Before the single judge, you withdrew your writ petition.
Sir, I cannot, sir.
Please come to, you have the paper book, sir. Your own file, page 10.
I have applied at a.
Sir, please refer to the judgment passed by single judge at page 10.
He's showing you that. This is your own paper, sir.
Sir, I have not agreed to discontinue, but Honorable Single Judge has pressed me.
Then you file a review petition, sir.
No, I have not written. He order or pass order. We advocate working there. Please write a memo for him. Otherwise, I will issue penalty to you.
If you say that you did not do it voluntarily, you are compelled to do it, you have to go in a review petition, sir.
Review review the first.
Yes, sir.
All right. Since the impugned order of the learned single judge records that the appellant who appears in person wanted permission to withdraw the writ petition, whereas the appellant now states that he never made any such statement. Or you filed a memo, it says.
Sir, for me, one advocate present there have written a memo. Honorable Single Judge ordered him write a memo for him. He will sign me here.
Can't believe that, sir. Once a memo is filed, you can't say it was by mistake. After filing a memo, how can you say it was a mistake?
I'm writing in my present petition. All the things I have written.
How can you now deny that you wanted to withdraw that petition?
Sir,
you filed a memo. You have signed the memo.
Memo had. I'm unable to stand here. He told me withdraw the case, otherwise I will impose the upon you penalty.
You filed a memo, sir. It's not just an oral thing. You filed a memo saying you want to withdraw.
Sir, ସେ ଭୁଲ ଲେଖିଲେ ମୁଁ କଣ କରିବି ଆଜ୍ଞା? ମୁଁ କହିଲି ପେନାଲ୍ଟି ଚାର୍ଜ ହଉ ମଧ୍ୟ ମୋତେ କଣ୍ଟିନ୍ୟୁ କରନ୍ତୁ। ସେ କହିଲେ ନାଇଁ, କଣ୍ଟିନ୍ୟୁ କରିବା ହେଇପାରିବନି, ତମକୁ ପେନାଲ୍ଟି ଚାର୍ଜ କରିବି ଚାହିଁଲି।
ସାର୍ ସେଇଟା ଆପଣ ଯୋଉଟା କଥା କହୁଛନ୍ତି ସେଟା ବିଶ୍ୱାସ ଯୋଗ୍ୟ ହଉନି।
ସାର୍ ମୁଁ ଲେଖିଦେଇଛି ଆଜ୍ଞା, ଆଉ ଏଇ ମେମୋରେ ଲେଖିଛି, ଆପଣ ଏତେ ଲେଖିଛି 17/37/2022 ଲେଖିଛି। On dated 17/10/2022, the Honorable Single Judge directed the appellant to withdraw the case. Otherwise, the penalty will be imposed upon him. The appellant prayed to the Honorable Court to consider his case and allow to continue the same, and he agreed to pay the penalty dues if imposed upon him. But the Honorable Court did not agree to
Mr.
continue.
Mahanti, you are appearing in this matter.
Tata Power.
Myself. What is that opposite party?
Tata Power.
Tata Power.
Tata Power. Tata Power.
When 31 is called out, you said you are appearing for the opposite party. When item 31 was called out, you told this court that you are appearing for the opposite party.
Power Central Odisha District. Tata Power or TPCODL. TPCODL, after notice goes, then I can appear. I cannot. Oh, no. I told in item 29, not in this matter.
Oh, 29 you put on slide. All right.
This is TPCODL.
All right. You see, counsel, the petitioner who appears in person claims that he never wanted to withdraw the writ petition, as indicated in the impugned order of the learned single judge. Is a notice returnable? You'll accept notice now only. There's only one respondent. Mr. Monty. Notice. Who has to accept notice, sir? Who's a lawyer? She accepts notice on behalf of the respondents. Mr. P.K. Monty, learned senior counsel appearing for the respondent, seeks time for instructions. List on
one. Two.
Both, sir. They're all.
Has made somebody is a personal pet.
Okay. To respond number 1, notice will go to respond number 2. Returnable. 22nd August. Just tell him that the date which he has to come back.
Matter fixed at 22nd August. What a copy. Extra copy.
Item number 32.
That to remove the defect, 1 week time.
List on 25th July. Defect be cured in the meanwhile.
Item number 33.
33 मेरा शर्त पड़ा मेरे that your lordship dispute of batch break.
Which group?
This is school, college.
School.
School group disposed of in terms of the order passed by the court on 8 May. My school group of cases. All right.
Item 34.
34. May I have the lordship kindly take this matter tomorrow? The file has been traced out just now. It was not traced out in the morning.
At the request of counsel for the appellant, list on 22nd August.
Item 35.
35, my lord, similar matters. That is connected to WA number 748 of 2023. Lordship had issued notice on 1st May of 2023. It has been adjourned to 2nd of 2/8/2023.
All right. Notice returnable second day. First. List along with?
I'm sorry, this is one of writ appeal number 748 of 2023.
All right.
Common judgment.
Right.
Item number 36.
36 and 37, Sattapata case, Lordship.
School or college or what?
College, my lord.
No, grant or
Direct payment or
direct payment or block in A.
My lord, I'm sorry. Just a second. This is one of direct payment, my lord.
School, the college direct payment
Yes,
matters. In terms of the college direct payment matters. Right.
Both 36
36 and 37.
So also 37, my lord.
All right.
Item 38.
38 months, 14th of September. Work charge.
Notice return. State.
Item 39.
39, my lord, there are some defect, my lord. Limitation petition to be filed, my lord. 2 days time may be granted. Let it come on Thursday, my lord.
All right. 1st August.
My lord, I pray for this week, my lord.
A lot of time you need, sir. I should not hurry you up. You need lots of time for curing defects. All right.
Item number 40.
May challenging the order dated 27/3/2023 passed by the
again defects. List on ninth August. Defects be cured in
Item 41.
41 works at 14th September.
14th September.
Item number 42.
42 similar case, you also dismissed that. I could not get that number. If you call this matter tomorrow, I can provide the number.
All right. Tomorrow.
Item 43.
43 DLR 25th September.
26th September. All right.
25th.
25th or 26th? 25th must
25th.
Yeah.
25th September.
Item number 44.
These are the items they should be taken up along with that Prawn-Giri matter 46. In that case, we have filed certain affidavits.
In fact, that Mohanty, Mr. Manoj Mohanty, he was mentioning a matter. His despite a status quo order, his Prawn-Giri was demolished. He says.
No. In that case, your lordship has directed to maintain status quo, but no prawn culture activities is permitted. We will not demolish their structures, but they are not permitted to undertake the prawn culture unless the registration is availed by the authority.
Anyway, we'll issue notice in that contempt. The exception notice. There's some contempt petition we filed. Oh,
contempt.
Okay. 2 p.m. is it?
That is at 2 p.m. If your lordship will fix it to after vacation at 10:30 or otherwise at 2 p.m. All collectors.
Yeah, 2 p.m. will take it up.
Yes, ma'am. Yes, sorry.
44 also at 2 p.m. 44 2 p.m.
Yes.
Item 45.
May I please, my lord? May I please, my lord? My lord, the opposite party number 2, opposite party number 6 is admitted that, and the opposite party number 7 has constructed the illegal construction by filling the earth, making construction of shop rooms. And the show cause filed by the Tahsildar.
Who's appearing for the contesting opposite party?
Private opposite.
So this, where is the private opposite party made a party, sir? You have not made them parties. The person who's illegally constructing, where have you made him a party?
And they are not included as well.
Those persons who you say are illegally constructing, have you made them opposite parties? Have you implemented them?
My lord, most of the villagers are suffering.
Kindly follow the question.
Yes.
I don't know where. Can you explain to him on Oriya?
Yes.
My Tahsil. No. My lord, Tahsildar in his show cause admitted that in paragraph 4, in contempt case number 1376 of 2016, in page 2, paragraph 4, admitted that that in reply of the averment made in paragraph 2 of the contempt petition, it is humbly submitted that the Honorable Court has passed order on 11/5/2016 in WBC PIL number 6670 of 2000 direction not to change
Sir,
the
please.
nature and character of the
Sir, have you made those who have constructing the who are illegally filling the earth as a party?
No, my lord. No. Only Sarpancha has constructed that dam. No, private party is not. That construction was made by the Sarpanch.
Who's appearing for the Sarpanch?
No, Sarpanch is not noticed, I think. I am appearing for the collector, the TOS.
According to the petitioner, the illegal construction has been erected by the Sarpanch, whose opposite party number 7. It does not appear that notice was served on opposite party number 7. Pravata Kumar Malik is represented by who? Sarpanch, bracket, opposite party number 7. We stop today, however, none is appearing for opposite party number 7. The registry will inform counsel appearing for opposite party number 7 to remain telephonically to remain present on the next day. List on 27 September.
Item number 47.
May I please, my lord? My lord, kindly have a glance to your lordship's order dated 14/3/2023. Order number 3. The ASI at CMC had to file their counter, my lord.
To 46. 46 at 2 p.m.
47.
Yes.
46, my lord, picked to 2 p.m.
Correct.
Lordship's item 46 will be taken up at 2 o'clock, Lordship.
Correct.
My lord, this petition has been filed to restore the Godakhai of Baravati Fort, my lord.
Yes.
Kindly have a glance to your lordship's order dated 14/3/2023.
Yes.
The ASI and CMC had to file their counter, my lord.
What happened?
Stipulated time given 30th April, my lord.
We cannot file the counter, Lordship may give the another after vacation, Lordship may fix any day.
Last opportunity to both the ASI and CMC to file their respective affidavits on or before 1st July 2023. Rejoinder will be filed for the next date. List on 13 July.
13 July, man.
Yes, please.
Mr. Bhukta is appearing with me.
All right.
My lord, in item 48, regional affidavit has been filed on 12th, last Friday. It is not on board, my lord, lordship's board. And moreover, my lord, the allegation made against OP number 6 and 7, though notice has been issued, they have not filed their response. May I please, lordship may issue press notice because construction has been carried out by OP number 7 at the base of OP number 6, my lord.
Lordship has directed me to give the status report. The photographs and the status report I have submitted. Regarding the status of that photographs are with your lordships in your lordship's file.
Rejoinder I have filed on the last Friday, my lord. Let it come along with the rejoinder affidavit. And lordship, since I have made allegation that construction has been being carried out by OP number 7 to the base of OP number 6, let them appear and file the reply, my lord.
Rejoinder statement have been filed, we brought on record.
The work is in progress and status quo order is running for last 2 years. The lordship can see the photographs. It is a Kalyan Mandap for the benefit of the local villagers. Block is developing this Kalyan Mandap. And on all these normal grounds, they have challenged. And this is, lordship may see how the construction is in the halfway. And
my lord, may permit to submit, my lord. Construction is being carried out over the plot of Jalasaya, my lord. That is water reservoir.
Lordship can see what
and
is
now, my lord, the state government is saying that construction is being carried out on the land 11 plot no 1195 with Kisam Adi. There is Bandha Adi. My lord, Bandha Adi is a part of the Jalasaya, my lord. If Bandha Adi goes, then there is no existence of Jalasaya, my lord.
There is in fact no Jalasaya there. This is only on record purpose. And Adi is not the Jalasaya.
Adi is a part of the Jalasaya, my lord. Without Adi, there is no Jalasaya.
I have given when that is Jalasaya, then Adi is required.
Jalasaya, Kisam is Jalasaya, unless
or it's a 14th August. Right.
My lord, the interim order will continue.
Yes.
My lord, lordship fixed to?
My lord, this is that Konarka matter where your lordship last time directed me to come with that state of Madhya Pradesh and MLK, sorry, that judgment.
Correct.
Lord, I have given a small note along with the relevant provisions of the rules as it existed then and now. And I have also given 3-4 decisions, including one of the decision of your lordships in writ appeal number.
Patita Pavan.
Patita Pavan.
All right. Let him study it. You say a note has been submitted today.
Lord, with much difficulty, I have got this matter listed before vacation. Lord, your lordship may pass orders. Your lordship has heard that matter. That for that last 22 years, he has been continuing in that post. They have given the benefit of the increments, higher scale of pay, and transferred him, treating him as a LFS employee throughout the state. And now they say that he cannot be regularized because it adheres the Rule 9. Rule 9 and Rule 7 as it existed then, my lord. I have given for a moment, your lordship may kindly have a glance, my lord. Last time your lordship was almost on the verge of dictating the order, only your lordship directed me that to bring in the
actual details.
So now the entire effort is nobody loses because I will not get any more promotion. I will get some
financial benefit,
pensionary benefits only in that state, and I have already received the pay that is due to me.
Lordship may consider, my lord. On last occasion, Lordship only directed my learned senior to give the MLK series.
All right. You see, the present writ appeal is directed against the impugned judgment date 13 January 2016, passed with a single judgment. In writ petition civil 6872 of 2004, upholding a reversion order dated 17 May 2004, whereby the appellant was reverted from the post of junior assistant to tax collector, which according to the appellant was contrary to the government guidelines and instructions. Full stop. The second prayer in the writ petition, which was rejected by the single judge, was for a direction to the respondent's state to regularize the services of the appellant as junior assistant, in which post he was continuing since 23rd December 1991. Paragraph. It requires to be noticed here that in writ petition civil 6872 of 2004, initially an interim order was passed on 10th August 2004, requiring status quo to be maintained in respect of the petitioner's service. Full stop. As a result, the petitioner continued as junior assistant and superannuated as such.
No, he has not been superannuated. Another 1-2 years is to go.
Okay, has been continuing as such.
By
Full
virtue
stop.
of your lordship's interim order.
Yeah, by virtue of the said interim order. Full stop. It may be noticed here that even in the writ appeal, by the order dated 18th February 2016, the said status quo order was continued. Paragraph. According to the learned single judge, it was mandatory for appointment to the post of junior assistant that selection had to be made by a selection committee constituted under
In accordance with Rule 7.
Rule 7 of the Odisha Local Fund Service Rules 1975, bracket 1975 rules. So, for the purposes of Rule 7, concurrence had to be obtained of the Director, Municipal Administration for promotion. Full stop. Inasmuch as no such concurrence was shown to have been obtained, the learned single judge rejected the prayer of the appellant. The question therefore posed was whether the appointment of the appellant as junior assistant in the local funds service, bracket LFS, bracket CADA, was illegal or irregular, question mark. Paragraph. It is contended by Mr. Ashok Mantil and senior counsel for the appellant that the executive officer of the municipality sent an intimation to the government on 30th April 1992 of the appointment of the appellant as junior assistant cum typist. Full stop. It is pointed out that prior to such appointment, on 5/12/1991, the government in the HNUD department, in fact, sanctioned one post of junior assistant cum typist under section 73 bracket 1 of the Odisha Municipal Act 1950 for the Konarak NAC in LFS cadre. Stop. Therefore, according to Mr. Mohanty, the appointment of the appellant as junior assistant was in compliance with both rules 7 and 9 of the 1975 rules. For the purposes of regularization of such irregular appointments made by municipal bodies between 10th September 1982 to 30th June 1992. A special selection under the OLFS rules was held, and the name of the appellant was sent for consideration of such regularization. Full stop. Although in the selection result published on 17th May 1999, the appellant's name did not figure, he was informed that this was for want of vacancy. Full stop. Nevertheless, the appellant was allowed to continue as junior assistant. Paragraph. It is only after despite the appellant having passed the annual departmental examination, when no action was taken to regularize services, that the appellant filed WP Civil 8702/2003, which was full stop. In the said writ petition, an order was passed on 1st December 2003, directing the government to consider the grievance of the appellant. Full stop. After this was rejected by the order dated 17th May 2004, the appellant again filed the second writ petition, being 6872 of 2000 filed 6872 of 2004. Sorry. Perspective of the conspectus of the above facts reveal that the appellant's appointment was at best single quotes irregular and not single quotes illegal. Full stop. This distinction for the purposes of regularization was drawn by the Supreme Court of India in State of Karnataka versus M.L. Keshari, 2010 9 SEC 247. Where it was observed as under.
Paragraph 7.
Paragraph 6, 7 and 11.
The above decision has been reiterated in Ahmad Khan Rai. Let's take this. Recently, this court, in its judgment dated 12th April 2023, WA number 777 of 2021, bracket State of Orissa was Patita Pavan Dattadar, applied the above law and upheld the claim of data entry operators engaged on contractual basis in the various taluks. So, that view of the matter, while setting aside the impugned order of the single judge, this court directs that with the appellant having served for well over 3 decades, his case for regularization should be taken up with an appropriate orders passed not later than 1st August 2023 by the state. So it is made clear that there will be no arrears of payment, although the regularization will date back to the initial date of appointment of the appellant as junior assistant. Full stop. In other words, it will be on notional basis for the purpose of calculation of retirement benefits and for promotion and seniority, etc. Paragraph. The appeal is allowed in the above terms, no other system.
Lord, may I can you only pray that your Lordship may also quash the order of reversion under Annex 20.
Correspondingly, the order of reversion referred to here and above also stands quashed.
My lord, I am appearing on behalf of SB Jana for Mr. SB Jana for respondent number 3 and 4, my lord.
All right.
My lords, the issues here with regard to SBI versus Siva Shankar Tiwari, that Molananda Sethi's case referred to the larger bench for a decision. Lordship has been pleased to issue notice in the matter and direct stay of operation of the order that already there. But since the issue is yet to be answered by the larger bench, I think Lord, matter should be adjourned awaiting the final decision to be taken.
Of the larger bench.
Right.
All right. You see, it is pointed out that has it already been noted in the earlier order?
Yes, my lord. Notice has been issued by your lordship by order dated 16th of March 2023.
And my lord, we have already entered appearance on behalf of respondent number 1, my lord. In both the matters.
16th of March 2023.
Correct. No, this other thing we are not noticing. Malay Ranjan said. On the issue of whether rehabilitation assistance should be, the plea for rehabilitation assistance should be considered in terms of the policy prevalent at the date of such consideration or the policy prevalent at the time of death of the employee in question.
Yes.
The matter is before a larger bench of the Supreme Court of India. Paragraph. Awaiting the judgment of the Supreme Court of India, these appeals are adjourned sine die with liberty to the counsel to the parties to mention them for listing after judgment of the Supreme Court of India. The interim order passed earlier shall continue. That's right. In the meanwhile.
May I please, your lord? The petitioner had filed earlier the case WPC number 6043 of 2002, my lord. And the case was listed in the weekly list. I am supplying the weekly list, my lord. That is weekly list dated 21/7 to 26/7, 2014. The counsel appeared, his name did not appear in the cause list. I am supplying the copy of the cause list, my lord. So the case was dismissed for default. If your lordship will kindly see the list, the earlier advocate name was there, but the present counsel, Anidya Mishra, was not there. I have given the
only writ appeal, right? Oh, just writ appeal against the order passed in CMAPL.
Yes, my lord.
All right. Who's for the other side?
University, Barampur University, notice to my lord.
Oh, notice returnable. July 25th.
Obliged, my lord.
All right. Give the slips. Yeah. Unopposed. Item 1 dismissed, none appears dismissed. Item 2, same order. Same order. Same order.
Your my lord, on the basis of the compromise, both the parties filed two separate applications, my lord. The other application has already been disposed of on the basis of the compromise. I'm passing
Counsel
the
appearing for responding to opposite party number 2 confirms that the parties have settled their disputes. The affidavit is also on record. In that view of the matter, you take from the prayer clause and all proceedings consequent that will be quashed. None appears dismissed.
May I please, your lordship, permitted to withdraw, liberty may be granted to raise this plea before the.
Permit the petitioner to raise all pleas. None appears dismissed.
Permitted to withdraw, lordship. 9 and 10.
Permitting petitioner to raise all pleas.
11 may I please, lordship. On last occasion, this honorable court directed government for instruction because the name of the petitioner in this case is doubtful. Your lordship kind have a glance. Actually, the name of the petitioner under Annex 3, page 20, Aadhaar card.
What are your instructions?
My lord, instruction we received, my lord. On verification of school administration register of such and such school, it is found that the actual name of the petitioner is Kumar Diptesh. He is called and known in the locality as Papali @ Babali Parida. His father name is Jitendra Parida and he is also called and known in the locality as Hagan. Accordingly, his name is reflected in charge sheet as Papali alias Babali Parida alias Kumar Diptesh, son of Gagana the same person, madam.
Right.
Same and one person.
No. In fact, my name is Kumar Diptesh as per educational certificate and as per Aadhaar. Your lordship kind have a class, page 20.
Let him
It's all
raise this
disputed. You
question
can
of
prove it
dispute.
now in the trial. The instructions are that the
one and same person,
the person whose description is found in the FIR and charge sheet, as well as the present petitioner, are one and the same person.
Yes.
This is disputed by counsel of the petitioner. Paragraph. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of in interim orders vacate.
May I please, your lordship? I am on virtual mode, my lord.
Yes.
My lord, petitioner is the general manager of Mahanadi Coalfield Limited.
Yes.
Your lordship will kindly see the present opposite party, who was an employee, he did not attend the office in time. So the officer in charge, Gyano Sahu, did not give him this present, did not show him present. Then when he created disturbance, he gotta go and meet the general manager. His allegation is that he came to the general manager's house and general manager abused him. He has filed a false FIR. In this case, notice has been issued, but he is not appearing. He has not appeared as yet, my lords. And there is nothing like, no other corroborating material that general manager abused him, and there is no reason for him to go to general manager also, my lords. And can it be taken up after vacation? I will take instruction in the meantime.
No, let us see if he's been served.
Yes, I will take special.
No noting has come regarding issuance of notice, my lord.
Yes, my lord. So notice has been gone. We have filed requisite.
When was notice issued? When was notice issued? I don't think notice was issued. No.
Yes, my lord.
Stay is granted without notice being issued, sir.
No, we have filed requisites.
When did you file? I don't think you ever filed.
No.
Notice was never issued, sir.
Then I will take notice by speed.
No. Why should we entertain?
Because the fact is that your lordship may kindly see the FIR for a second. If I think it is in vernacular language, anyway, paragraph 3, your lordship may translate.
SC/ST Act, sir. This is all SC/ST Act.
Because merely saying that he abused me in SC/ST Act as general manager rank officer, there is no reason.
Let a charge sheet at least be filed.
No, here no. The matter is on investigation stage.
Correct. Let that be completed.
No, your lordship, just hear for a second. My instruction is final form is being filed. It is a false. I'm only praying that it will be taken 3 days.
Then it's all the better. Why should we keep it pending? Not necessary.
No, 2 days after your lordship, I will tell the instruction.
Not necessary.
But otherwise, the officer will be harassed for no fault of it.
You yourself are saying a false report is being filed.
Yes.
Closure report is being filed. Where is the question of harassment?
No, your lordship may keep
you
it.
You yourself are saying a closure report is being filed, sir.
Yes, your lordship may keep it to tomorrow.
No. Not necessary. Not necessary.
Tomorrow, Millers.
Sorry.
I'm not saying for more date.
No.
Tomorrow,
the court is not inclined to entertain this petition at this stage, permitting the petitioner to raise all pleas at the appropriate stage. The petitioner is disposed of. Interim order is vacated. Yes. None appears discussed. Same order. Same order. Same order. Same order. Same order. Same order. Same order.
Lordship permitted to withdraw.
All right. Dismisses withdrawn.
No.
None appears dismissed.
Maybe. This self-safe allegation 3 FIRs has been filed, my lord, for the same incident, my lord, relating to taking possession of the land. The petitioner are Adivasi people. They are in possession since long, from the time of their grandfather. And when the possession has been taken, there is a tussle between the
in this
contractor
case,
and
charge sheet has already been filed.
Oh, I see. Permitting the petitioner to raise all pleas at the appropriate stage in all 3 matters. All right.
Brief was transferred. Our name may be deleted.
Stated that brief has been transferred. None appears. Petition is dismissed for non-prosecution.
May it please your lordship. And the petitioner here has challenged his rejection of section 457 application first by the court of STGM Palwada and subsequently in the criminal revision before the additional session judge Culture, my lord. My lord, in this case, initially FIR was registered against registered that the vehicle of the petitioner, which was carrying 3 cows for selling purpose, met an accident. The petitioner was not in the said vehicle, and subsequently when the charge sheet was filed, the petitioner was not made an accused also. 3 persons were found in that vehicle, and on that basis, subsequently the petitioner filed an application under section 457 of CRPC for release of that vehicle. However, that vehicle was, that application was rejected on the ground that since the Rule 6 of Odisha Motor Vehicles Accidents Claim Tribunal Rules 2018 does not permit the release of a vehicle that has no third-party insurance cover, and the present vehicle had no third-party insurance. However, the said rule, the petitioner challenged the said order in a criminal revision. The order was upheld by the learned additional session judge, my lord. However, my lord, I have reproduced the said rule at page number 8 of my application, my lord. My lord may find that as per the said rule is not an absolute rule. The rule, with the lordship's permission, my lord, may I read, my lord? The rule says, no court shall release a motor vehicle involved in an accident resulting in death or bodily injury or damage to property when such vehicle is not covered by the policy of insurance against third-party risk taken in the name of registered owner, or when the registered owner fails to furnish a copy of such insurance policy despite demand by investigating officer, unless and until the registered owner furnishes sufficient security to the satisfaction of the court to
What
pay.
happened in the incident, sir? What actually happened?
My lord, the vehicle was coming from Keonjhar.
What is the vehicle?
It's a Tata S vehicle, my lord. It's a Tata S mini truck, my lord.
Mini truck.
Mini truck. The vehicle was carrying 3 cows, my lord. It was moving from Keonjhar side. The present informant, while coming on the road, found that the vehicle had derailed from the road and went into the jungle side, my lord. And after that, he lodged an FIR, my lord. He lodged an FIR. In the said FIR, the investigation was conducted and charge sheet was submitted. And the present petitioner before your lordship is, my lord, the owner. The owner was not in the vehicle. Also, the owner was not charge sheeted after the investigation, my lord. The owner moved an application.
The vehicle simply moved into the forest. It says it was an accident.
Made an accident, my lord.
You never said that. You never used the word accident. You simply said it went into the forest.
No, made an accident. After accident, it
accident with what? With whom?
That is not in the FIR, my lord. The informant saw that the vehicle has made an accident and moved into the jungle side.
Met an accident means what accident, sir?
Not as for the investigation, also it is only there that due to rash and negligent driving of one of the driver of the vehicle, he lost balance and went into the jungle segment.
So, which means you're not reading your own paper book. This only makes it absolutely clear that you're not reading even what you have written. Come to page 3. You never prepared for this case.
I prepared.
Come read para 4 now.
Prosecution allegation as per the FIR is that on 8/11/2020 at about 11 a.m. the informant was returning from Keonjhar. On the way near Sanajhar Chor Ghati, the informant saw one Tata's vehicle bearing number so and so lying inside jungle facing road accident while transporting cows. Out of 3 cows, 2 have died and 1 was alright. On being asked the helper of the said vehicle, he stated that he along with his father Tengu Dehuri have brought 3 cows to sale in Chamunda Hato. Rabi was driving the Tata's vehicle. Since the driver has sustained more injury, his father has shifted the driver to hospital. The accident has taken place due to reckless driving of
the driver sustained injury. 2 cows died.
My lord.
And you're saying nothing.
No, my lord.
When I asked you what is the accident, what happened, you're not able to say that 2 cows died. You're not able to say the driver got injured. Nothing. I have to make you read it for us to understand these facts.
I was coming to that.
You will come to it whenever you will wish to come to it. When I ask you, you don't come to it. So you have to be clear on facts. This is your case. If you're not clear on facts in your own case, what is the point? There is a line in the impugned order which says you are not depositing security for compensation to the victim. And you don't mention the name of any victim. The way you're describing facts is as if there's no victim.
Well, there are victims. Can you have a glance to page number 29, my lord?
You're not ready with the case. It's very obvious you're not ready. You're simply arguing without even the facts, placing the facts before the court.
I'm willing to file the compensation amount, my lord. As per Rule 6, the claim amount that may be raised in a claim tribunal in the future, I am willing to pay that security amount, my lord.
You have to first be clear on the facts. What is the age of the victim? What was the injury? No idea. How do you argue matters like this, sir? Without facts? Very surprising. You see, the petitioner, counsel for the petitioner is not ready with the facts of the case at all. He's directed to file a detailed date chart, setting out properly all the facts to enable the court to appreciate the issues involved. List before the roster bench. Which item is this? What are your instructions, sir?
My lord, your lordship may kindly page 25. Your lordship may kindly see. Let the page 25.
No. What are your instructions? No instructions.
Instruction, my lord. The revision. It was also affirmed the order of the SDJ, my lord. And also Rule 6 of the...
No. Instruction means any charge sheet filed. What has happened to the FIR?
Yes, my lord. Charge sheet has been filed. Charge sheet has been filed.
Under what provisions?
My lord, charge sheet has been filed under section 279, 337, 338, 429 IPC, my lord. Against the accused driver Rabi Yes, my lord.
All right. Let's go for the roster bench. Let that line remain on 19 July.
Item number 26.
My lord, here, the opposite party number 2, who is the father of the petitioner number 2, lodged an FIR under Annexure 1 that her daughter has been kidnapped. My lord, both the petitioner number 1 is the person against whom allegation was made. Petitioner number 2 has joined the petitioner number 1 just to impress upon this honorable court to show that there is no such, it's a false FIR. The daughter has gone in her own volition and they are residing.
Yes, my lord, I have received instruction.
Mistake of fact. All right. It's already in fructuous. The GR case 87 of 2021 corresponding to Sonpur PS case number 91 dated 18th April 2021 has now been closed with the final report of single court's mistake of fact dated 31 July 2021 having been filed. So the report dated 14th May 2023 of the IIC Sonpur PS, while confirming the above facts, also states that petitioners 1 and 2 are staying together as husband and wife. So the petition is therefore disposed of as having become infructuous.
Grateful, Your Honor.
Item 27.
My pleasures. And a passing of proceeding on the ground of compromise. I have made informant as a party of number 2, and the matter has been amicably settled. The allegation is that the petitioner.
Where is the affidavit, sir?
Well, the affidavit is not there. Your Lordship Director will file the affidavit.
Counsel for the petitioner seeks time to file the affidavit of.
Well, 2 weeks time.
No. Whose affidavit?
Informant affidavit
of opposite party number 2 regarding the matters having been settled. List before the roster bench. On 25th July.
Item number 28.
None appears dismissed.
29.
29, Maharaj may allow us to withdraw the matter.
Dismissed is withdrawn.
Item number 30.
30, my lord. Here, my lord, the matter has been compromised and the affidavit has been filed by the informant. And
I am appearing informant.
All right.
Matter is a compromise.
What's the offense, sir?
Offense under section, my lord.
31, no?
341, 294, 354, 506, 34 of the IPC and read with under section 32VA SCST Act.
That's the problem, sir.
Not problem. But there is a judgment of our own High Court that in SCST Act, no matter is compromised, then it can be disposed of.
Where is it?
That judgment. On next state, on any day.
File it. See, at the request of counsel of the parties. Let's move the roster bench. On 25th July.
Yes, ma'am.
Item 31.
That one may please the lordships. My lord, the present petitioner is the informant, my lord. The brief fact of the case is that, my lord, the accused person had taken 2,72,000 fraudulently from the petitioner, my lords. Subsequently, the accused was arrested and his account was freezed, my lords. The humble prayer of the petitioner is that, my lords, rupees 2,72,000 kindly be given to him, and he had filed a petition under section 457.
It's been investigated, sir. Not at this stage. Without investigation, how can the money be given to you? Charge sheet has been filed.
No, man.
At this stage, how can money be released?
My lords, may kindly have a glance at page number 20, my lords.
All right.
May I read the relevant portion?
Yes.
That the IO has not submitted transaction details, deposit receipts, or counter challenge with respect to transfer of rupees 2,72,224, my lords. My lords, may kindly have a glance at page number 12. I have given all the transaction details. So I humbly pray that kindly the transaction details may be considered and the court below may kindly consider my prayer.
It's premature, sir. It all has to be only at a certain stage. You withdraw it at the later stage, you file it. So counsel the petitioner seeks leave to withdraw the present petition.
Post charge sheet,
Liberty to seek appropriate remedies at a later stage in accordance with law. Disposed of is withdrawn with liberty as straightforward.
Item number 32.
None appears.
33.
Same order.
Item 34.
Same order.
35.
I appeal for the OP2, Your Honor. In 34.
All right. None appears to the petitioner. Dismissed for normal.
Item 35.
Well, 35. Well, in this case, I sent notice, but not it is found. But he is residing in two addresses. Opposite party number 1 is staying in two addresses, Jajpur and Cuttack. And he is filed a family court case before the Jajpur and at Cuttack. And I can directed to file any one station.
What are you challenging?
I am challenging that he is residing at Cuttack, but he is filed.
Challenging? What are you challenging?
Total false and fabricated allegation against me. Well, he is filing a DV case also against me, which is
all misconceived, completely misconceived.
My lord, family court case is pending. My lord, he is asking for alimony there, but he is also apply a year for alimony.
All right. The court is not inclined to grant any of the reliefs as prayed for. The petition is dismissed.
Item number 36.
The memo is taken on record. Dismisses withdraw.
Item 37.
May I please, Your Worship? Cognizance taken under section 366, my lord. But the opposite part to 2, the father of the opposite part 3, my lord, law the information regarding kidnapping of the opposite part 3, my lord. But in fact, they have married and the opposite part 3 gave birth a female child. They are residing together, my lord, happily, my lord. They also.
You are appearing, madam.
But I am appearing for the.
All right. Counsel appearing for
opposite party number 2. They are both present, my lord.
All right. Opposite party number 3 confirms that she has married the petitioner and they are now living happily together. They have also got a child. Full stop. The affidavit of opposite party number 3 is also on record. In that view of the matter taken for a clause and all proceedings consequent that were hereby quashed.
And one thing, my lord, earlier this case pending before the JMFC R, my lord, now JMFC 1, my lord.
Right.
I haven't mentioned in the affidavit. JMFC 1.
All right.
Obliged.
Right.
Item number 38.
None appears dismissed.
39.
Item 39, my lord, may be permitted to withdraw with liberty to raise the grounds before the appropriate stage.
All right.
Item 40.
My lord, on behalf of Bhagavat Ratha, sir. My lord, after vacation due to defect remove.
No. Tell me what the matter is. All right, you just say permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of.
Item 41.
Okay. None appears dismissed.
Item 42.
Item 42, Lordship, permitted to withdraw with a liberty to raise all the objection in
all right. Permission to raise all pleas.
Item 43.
May I please, Your Lordships? In the given case, there is noting that the Gujarats have been filed, but the
tell us what the matter is about.
The matter is with regard to challenging the order by Annexure 1, whereby the London Additional Sessions Judge has passed the order enhancing the maintenance at the instance of the appeal was filed by the petitioner.
From what amount to what amount, sir?
That was initially 9,000 by the non court below, but it has been enhanced to 10,000, my lord.
That's it. 9,000 to 10,000. What is the big deal, sir?
No, the grievance is that, my lord,
the minor daughter is also there.
That's fine, my lord. But
So daughter gets 4,000, wife gets 6,000, sir.
But the wife has.
Where are they staying? Where are they staying? The city.
No, it is in village, my lord. It is a remote village in the block area.
It's all right. But you need at least this much amount, sir, to sustain.
No, the thing is that the learned court below has failed to appreciate the other contention of the petitioners.
What contention? What contention?
Lords may kindly see.
What is your salary?
I have to take instruction to that effect.
No.
Because it is a primary school teacher, your lords.
Yeah. They all, definitely the salary must be 30,000 minimum. 30,000 is minimum. 1/3 also, if you can't pay for your wife and child, what's the point, sir?
But the wife voluntarily left the company of the husband.
All that has nothing to do as far as maintenance is concerned.
As your lords please.
All right. The amount of maintenance being awarded to the wife and minor daughter for the petitioner being rupees 6,000, rupees 4,000 per month respectively. The court does not consider this unreasonable, particularly considering that the petitioner is working as a teacher in an upper primary school in Ganjam in Odisha. Consequently, the court is not inclined to declare the petition is dismissed.
Item 44.
Copy of this order be sent to the concerned court for family court. None appears dismissed.
Item 45.
Same order.
Item number 46.
Well, here the cognizance was taken under Section 3 SC/ST Act by a complaint made by a social worker. Neither the victim nor her parents nor anybody of their community have complained of. Your lordship will kindly turn to page 12, my lord. Initially, she has filed a complaint case.
What's the current position?
The charge sheet has been filed and cognizance.
I am challenging the order of cognizance.
Page 51, your lordship may kindly see.
Charge sheet has been filed, madam. This all
Your lordship will kindly see whether a complaint is, my lord.
That stage has crossed. You can still argue all this at the stage of charge. You can still argue all this.
Yes.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed.
Item 47.
None appears dismissed.
Item 48.
Lordship, please, Lordships, I'm on BCO, Lordships.
The
petitioner seeks to assail the order dated 12/11/2020, wherein the learned JMFC has taken cognizance under Section 498 along with other allied offences. Here, this is a counterbalance to the application under Hindu Marriage Act, Section 11 at 5. Lordship had annexed to 1.
Charge sheet filed, Ms. Naidu.
Your Lordship, they may be a compromise, Your Lordships, because I have filed an application under Section 11 for void marriages. That was on 16/3/2019.
Whenever there's a compromise, you can point out to the trial court.
Your Lordships, notice had been issued, they have not appeared.
No, it's not been served. It won't be. All right. You just see.
Home guard, Your Lordships.
No, it's all right. Permitting the petition. You have to settle matters ultimately. If you can't settle, that's the whole problem. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right.
Item 49.
Well, it's 49. I pray for liberty to raise the grounds.
Right. Permitting the petition. All right.
Item 50.
May I please, your lordship, here the petitioner is a my lord belonging to the sitting MLA of the Chilika constituency. When he was at the Jilla Parishad office and distributing the my lord the beneficiaries, the informant belongs to the BJP.
Your client is very famous,
my lord.
English, they have different words: famous, notorious. Yes. What do you want to do?
My lord, as your lordship pleases, my lord, the allegation, my lord, so far as the allegation of SC/ST, all these things, that is not there, my lord, your lordship will
let them investigate.
Find from the page 21.
As it is, they'll slow down investigation because of things like this. All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right.
51.
May I praise your lordship. A passing of proceeding on the ground of compromise. Yes, I made OP number 2, 3 and
I already appeared file my
affidavit already filed.
What are the offenses, sir?
Offenses, my lord, these petitioners are, my lord, helping the out of love relationship. The victim came with the
all right. The affidavits of the opposite party, 2, 3, and 2 and 3 are on record.
2 and 3.
Yeah. It appears that opposite party number 3 she's married.
Married to another person.
Married some other person and is living peacefully. But there's 376, sir.
Yes.
Problem.
And here, my lord, the petitioners are friends of the main act. The petitioners are not main allegation. Main act, she came with one Jitwala Jitendra Samudra. We are friends, my lord. That are and married to another lady. We are friends, my lord. We are, my lord, friends of that. Not against 376 against the petitioner, only abatement, that is 366, 363. And that is when my friend is also appearing 2 and 3, my lord. He has currently stated, my lord, he has already married, conjugal life, my lord. But
what are your instructions, sir?
My lord, the charge sheet has been filed under section 376. My lord, cross-examination by the defense, trial has commenced.
Not at this stage, sir. Trial has commenced, not at this stage. You can always get into the box and say whatever she wants to. As it is, sir, 90% of cases are ending in acquittal because of things like this.
My lord, here, my lord, he has already married to, that's why. That's
not at this stage. Not at this stage.
And
we permit you to raise all pleas, sir. Permitting the parties to raise all pleas at the appropriate stage. The petition is disposed of. Sorry. Right.
Item number 52.
52, Lordship, I may be permitted to raise all such points at the time.
All right. Permitting the petitioner.
Item 53.
May I present? The order at Annexure 3, along the application under section 205 has been, I'm assailing the order.
What are the offense?
The offenses are under section 109, 120B, 420, 463, 465, 467, 468, 471, 475 of IPC. Let's say 467.
Obviously, some scam.
Yes, Your Lordship. Lordship, this 467 and 465 the life imprisonment is prescribed, Your Lordship. And Your Lordship, in the impugn order, they have relied upon a decision which is expressly not applicable.
Anticipatory bail dismissed, correct?
Your Lordship, I am for the complainant, Your Lordship.
Oh.
The accused person's 205 is allowed, and I haven't.
You're the other side, okay.
Yes, Your Lordship.
Have they got bail?
That is not within my knowledge, Your Lordship.
So if they get bail, you can go for cancellation of bail if they're really threatening you.
Lordship, once a 205.
Why should you come for a 205 exemption?
Lordship, they have filed a 205. The 15/11/2022, the cognizance was taken and summon was issued to them. On 25/11/2022, the 205 application, Your Lordship, I have annexed the application at Annexure 2. That has been allowed.
Have they got bail? Have they not got bail?
That is not within my knowledge.
How can you? That is all too basic, madam. In a matter like this, how can you not know that?
Your Lordship, kindly call this matter tomorrow, Your Lordship.
When you sat down to draft it, you should have, this is the first question you will ask.
Grant me one passover.
It's all right. You say at the request of counsel for the petitioner. Let's move for the roster bench on. Keep it in the opening. 26th June. All right.
Much obliged.
Item number 54.
My lords, 54, my lords, the prayer has become infructuous.
All right. Counsel, the petitioner states the petition has become infructuous. It is post over. All right.
Item 55.
None appears dismissed.
Item number 56.
Say what?
57.
May I please, your lordships?
Yes, please. Yes.
In the given case, my lord, there is a case and counter case by the parties, and your lordships have been pleased to stay the further proceedings by the OP number 5 in CRLMC number 1317 of 23.
Right. 1317
of 23, my lord.
When is that coming up?
That was your lordship on 4th May.
Oh no, date, next date. 1 minute, we'll find out.
This sum. the High Court server was down, so I could not get the information.
It's coming on 5th July.
All right. List before the roster bench along with 1317 of 2023,
My lord.
5th July. What is the order in that?
Stay of further proceeding has been passed in that
All right.
case.
Notice returnable, stay of further proceedings till then. All right.
Your lords may kindly stay the
Yes, state.
investigation in this case.
Yes.
Item 58.
Oblige, your lordships.
None appears dismissed.
Item 59.
Same order.
Item 60.
None appears dismissed.
61.
Same order.
62.
Same order.
Item 63.
Same order.
64.
Same order.
65.
My lord, please, my lord. My lord, here the petitioner is a driver. He is driving the vehicle, and the vehicle was also seized by carrying some contraband ganja. The person who was also taking that contraband ganja was also arrested. He is also detained in custody because I am the driver only to carry out the order passed by my master. So I have been in
don't say my master.
My lord.
At this stage, don't say my master. That itself will grant you trouble.
My lord, the NBW has been issued on 10th January 2022. Only my prayer is allow me to surrender and also to consider my bail application.
No, sir. Sorry. It's not possible. What do you want to do, sir?
My lord, pass the order.
All right. The court is not inclined to grant the prayer of quashing of the NBW, considering that this is an offense under the NDPS Act. The petition is accordingly dismissed. Put on the prayer clause. Right.
Item 66.
Raise all the point at the royal court.
All right. Permitting the petition to raise all these.
67.
None appears dismissed.
Item 68.
May I please, my lords. Lord, Annexure 5 is the improved before lordships. That is order, page number 819, order number 227 has been rejected by the court, my lord. I draw your lordship's attention, Annexure 3, page 14, my lord. During that it is, my lord, offense relating, my lord, 138 of NI Act, my lord. During pendency of a 227 petition, Annexure 3, page 14, your lordship kindly, my lord. I have filed a time petition. That time may be given to the 3-day time so that, my lord, I will argue the matter, my lord. That petition was there, page 14, my lord. Lordship got 14. That time petition, my lord, dated 21/11/2022, that has been rejected and one Annexure 5, my lord, passed. That no time will be given to you. And the lordship kindly say Annexure 5, the time petition rejected on the ground of, my lord, rejection not maintainable. Annexure 5, my lord, this page 22, the improved lordship. Time petition rejected, and my 2-2 petition, the discharge petition, rejected on the ground that not maintainable. That is on page 22. (138) NI Act, compromise at any time both the parties may compromise, but time petition given only silly grants that 2-7 petition rejected.
But all this has happened in November, sir.
Again, that's similar.
By now you should have compromised. Obviously, you're not willing to pay any money. This is a problem. Check amount is 6,55,000.
My lords.
Some
amounts have been given, my lords.
What is some? Some means what?
Some amounts have been given, my lords.
More amount been given to the lawyer for fees. That's the point.
No, Odisha advocate, my lord, Odisha advocate taking a very low type of cases. My lords, and the amounts is very low, my lord.
That's the problem, sir.
Because Odisha lordships know better, my lord, that very. The silly point, my lord, that ground taken, my lord, rejected. I want, my lord, some time may be given so that petition.
See, if you
Notice-
come, you withdraw. So whenever you come to a compromise, then you file all this.
My lord, if a lordship issue notice, then the here my lord compromise chances only notice notice goes so that my lord the
Are you
private.
willing to make a payment? Then we'll issue notice.
My lord,
What? What payment will you make?
my lord, after notice, my lord, I will, my lord, both
Doesn't work like that, sir.
OTS, my lord, one time
We have to see
settlement.
what is your bona fide? What are you willing to pay?
My lord, I am willing to pay, my lord.
What are you willing?
I take my lord instruction 50%, my lord.
So counsel the petitioner wants to take time to take instructions on whether the petitioner, without prejudice to his rights and contingency, is willing to pay 50% of the check amount to the complainant with a view to settling the disputes. At his request, list on 26 June.
My lord, issue not let.
No. First.
Like lordship, what happened, my lord? Unless your lordship stay in the proceeding,
you show this order to your client. He'll understand.
Lordship, my lord, I may be
He's probably watching it also.
Oh, yes, my lord. I may permitted, my lord, that particular matter sentence, my lord, you said, my lord, party will otherwise take that you have to why you have taken 50% without touching. That's what
He will anyway
that's
ask
simple.
you.
Yes, simple.
He'll probably watch this proceed.
And a simple lordship adjourn the case, I'll take instruction. That time,
no.
50%, my lord, unless my lord state, my lord. Sorry, my lord, I'm so disturbed, my lord.
No.
Only 50%, my lord, that I've stayed, my lord, that word, my lord, I would draw, my lord.
Then you withdraw the petition itself, sir.
Again.
Let's not counsel the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies at the appropriate stage. All right.
Item 69.
May I please, your lordship?
Yes.
Lordship, here the complainant has filed lost the FIR against me, and this is the continuous endeavor of the complainant since 2020 to harass me by virtue of an deed of declaration of marriage. Virtually, we were in love with each other, but on later on, due to certain reasons, we missed it and we didn't marry. And to take revenge on me, she's trying to put me in harassment. She's lodging FIRs continuously. Lordship, in the 2020, she tried to lodge FIR in Mahila police station.
Sir, this is a 376 case.
Lordship, that is right. Lordship, 376 case, just have a glance on the previous FIR that was in the year of 2022.
Yes.
Lordship, the 21 study, Lordship. And next.
Lord, there are sufficient allegations against the petitioner under the FIR. Therefore, the investigation is going on.
Lordship, Annexure 2.
Yes.
May I be permitted?
Yes.
Yes, Lordship. Lordship, in the Annexure 2, she has lodged an FIR against me by virtue of this deed of marriage that under 498A, 294, 313. 313 was there, 506, 406, and 34 due to Dowry Prohibition Act, Section 4. Lordship, investigation was completed, and as per the charge sheet, both 313 and 406 was deleted from the charge sheet, and even my father was also omitted from the charge sheet. Lordship, then she tried again me to put in trouble, and she lost this FIR just by sending the FIR to the Mahila police station in the year of 2022.
Yes.
Through post, and by virtue of one CRLMP number 240 1997 of 2022.
Yes.
The Honorable Court has directed the Mahila police station to lodge the FIR, and the FIR was registered. And then also she made another application before this Honorable Court by virtue of CRLMP number 241 of 2023, in which I was directed. It was sent to the Mediation Center of Honorable High Court of Orissa, and I appeared before that Mediation Center also virtually on the date on which it was fixed initially. At that time, I was at Bangalore, and that is why I couldn't appear. But in the next date, I appeared on 21st April 2023. But unfortunately, she misrepresented this honorable court while the on 25th May 2000, sorry 25th April 2023 that I didn't appear before that mediation center. But see, where the issue is that when you have pleaded in the previous FIR, also the year of 2020 when she lost the FIR before Mahila police station and Info City police station, there was no copy available with me, but police called me on various times and apprehended me, and accordingly I have also resorted to this honorable court and I have filed an ABLAPL number 11040 of 2020. Then also in the year of 2021, I have also applied one bail application ABLAPL number 8571 of 2021, and I was also allowed with that, and I surrendered before the court, and the case is pending before the JMFC 3, Honorable Court JMFC 3 Bhubaneswar. Then how this FIR can be lodged against me presently when I am not at the stage?
So let this matter be investigated.
Lordship, I agree. I will welcome this matter to be investigated. But thing is,
my lord, only for this accused person, my lord, the charge sheet cannot be filed.
That's all.
My lord, he is not cooperating. This is a case under section 376, my lord.
Correct. Have you got bail, sir?
Lordship? Have
you got bail?
No. I have not applied for bail.
So you're taking your chance.
Absconding.
Very good.
No, Lordship.
Yes.
Lordship, it is purely vindictive when it says that I have provided all the papers. Lordship, just have a glance in the Annexure 5. Annexure 5 is an agreement which she claims that it is an agreement, deed of declaration of marriage, where only the father and mother of the complainant was there. Dr. Annapurna Mahapatra and Dr. Ashok Kumar Chinera. Ashok Kumar Chinera is the father of the complainant. Dr. Anupama Mahapatra is the mother of the complainant. They were only the witnesses of the agreement deed.
All right. I'm not inclined, sir, permitting the petitioner to raise all pleas at the appropriate stage. The petitioner is disposed to. Right. Put the prayer clause in this.
Item 70.
May I please your lordship? Lordship, the wife of the petitioner, namely Josna Rani Sahu, is suffering from obstetric and gynec disease and was fastly treated at DHHA Dhenkanal. Lordship, the doctor noticed her to SCB
Just
Medical.
put this IA number 718. What are your instructions, sir?
SCB Medical College. And Lordship, now the petitioner is at the stage of dose.
All right. There's a report of the IAC, Sadar PS Dhenkanal, stating that upon inquiry, it was ascertained that the wife of the present petitioner is suffering from chest and abdominal pain since long and is also undergoing treatment at the SCB Medical College and Hospital, Cuttack, as well as the DHH Dhenkanal. He has also confirmed the genuineness of the medical documents of the wife of the petitioner. In that view of the matter, it is directed that, subject to the satisfaction of the trial court, the petitioner shall be released on interim bail for a period of. What's the offense, sir?
Lord, may grant 1 month time.
All right, 4 weeks. Subject to his surrendering immediately upon the expiry of the 4-week period, and the proof of surrender be placed on record. The application is disposed of. All right.
71.
71, my lord. Here 2 matters have been. One is CRLMC 1387, another is CRLMC 1386. My lord, here in both the matter, Matter has been compromised between the parties, my lord, and affidavit has been filed.
What is the offense, sir?
In first 1387, the offense is SC/ST, but in 1386, my lord, offense under section, my lord, 341, 294, 323, 325, 506, and 34 of the IPC.
Second one's all right, not the first one, sir. Where is the affidavit?
Affidavit have been filed, my lord.
Where? Where is that? When did you file it?
Filed undated.
It's not on record, sir. Not on record.
Well,
The affidavits stated to have been filed are not on record. List before the roster bench.
Next date on any date may be fixed, my lord, so that informant is have already been appeared.
Charge sheet must have been filed.
No instruction.
You better find out.
Yes, ma'am.
List before the roster bench on 28 June. In the meanwhile, the counsel for the state will inform the court of the present status of both the criminal cases.
Item 72.
Man appears dismissed.
73.
Same order.
Item 74.
73 minor, no instruction.
73 dismissed for no instructions. All right.
74.
Please, your lordship. On the last occasion, lordship was pleased to issue notice the appearance of opposite party number 2. The case arises out of a complaint case which is registered under section 420 and 406. Lordship may kindly see annexure 3 Millards at page 25. There is a compromise that has been effected between the parties who are brothers Millards. And
all handwritten, sir.
But it was filed in the court below. In view of this also, Millards, the learned magistrate took cognizance and I have agreed by the order of them. I had filed the requisites for notice also, Millards.
I don't think anybody is appearing. Wakalatnama, we have the petitioner.
Millards, since the previous filing counsel expired, Millards, I had filed a fresh Wakalatnama.
What is your instruction?
Instruction, my lord, cognizance has been taken, my lord.
That's all.
No, my
But
lord,
stay
so
of
far
further
the
proceedings.
set-
No, on this compromise.
Yes, my lord. So far the settlement is concerned, but no instruction I have received.
The IIC of the concerned police station will, you said none is appearing for respond, but opposite party number 2 despite service of notice. The IIC of the concerned police station, which is IIC Sundargarh, Town PS Sundargarh.
Town PS Sundargarh.
Will ascertain from opposite party number 2 if indeed there is a compromise between the parties. List before the roster bench on 28 June.
Item 75.
Well, it's interim order.
Interim order to continue.
Grateful, Millards.
75.
May I please, your lordship? Well, here the petitioner files this appeal for quashing of the inter-criminal proceeding, my lord. Yet the affidavit already compromise has been made.
What's the offense? What is the offense?
Offense under section 498, 323, 506, 294, my lord.
Who's appearing for the victim?
Affidavit is at my lord flag B, my lord.
It's been served. Acharya had appeared earlier. Where is he? It is seen that one Mr. L. Acharya, advocate, was appearing earlier. Lambodar Acharya was appearing earlier for opposite party number 2. However, today he is not appearing. The registry would telephonically inform Mr. Acharya to remain present on the next date.
Obligation.
This before the roster bench, 28 June.
Obligation.
76.
My pleasure. This case arising out of the complaint case under order challenging 238-13 CRPC was rejected on the ground that 197 is required. The petitioners are the police officers. And the annexer sees the opposite party number 2 is the accused on that case. Was cuthold going to her house for cutholding. This incident was happened. When 197 CRPC is required for proceeding of the criminal.
That you can raise at the appropriate stage.
Yeah, because charge has already framed, statement has already made.
So anyway, that's the whole point.
Page 20, the
This is custodial violence, correct? What is he complaining about?
Complaining on that day faithfully, I came to house of the opposite part number 2 and cut hold their necks and giving a fist and blow.
That's what. This is not official duty at all, sir.
Because under Annexure 6 is the accused that was prima facie reveals, and he has the other antecedents. 3 to 4 antecedents.
Order framing charge you must have challenged.
That
Did
was
you challenge that?
No, I am not.
Then permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of, interim modificated. All right.
I am appearing for the opposite party. 77.
May I please, my lord? My lord, I am challenging the order taking cognizance under Annexure 3, that is order dated 29/7/2020. It is a dispute between the husband and wife. Matrimonial dispute, your lordship. Offences are 498A, 323, 506, 34 of IPC. Read with section 4 of the DP Act. Already matter has been amicably settled. Annexure 4 is the mutual affidavit filed by the parties, your lordship.
Who is appearing for her?
Already notice has been issued and counsel is also appearing on behalf of the OP number 2, your lordship.
Who?
Mr. Shiva Prasad Mishra and Associates.
Where are they?
Name is not reflected.
Huh?
Their name is not.
Name is not reflected. Vakalat number there at least.
No.
You said despite valid service of notice, none is appearing on behalf of opposite party number 2. The IIC of the High Court PS. District Kyonjar will ascertain from the complainant in PS case number 36 of 2020 whether there is in fact a compromise reached between her and the petitioner. The report of the IIC be placed before the court on the next date. List before the roster bench on 1st July. 31st, 3rd July. All right.
Item 78.
May it please your lordship. Lordship, may I be permitted to place on VC lordship?
Lordship, interim order to be continued.
Okay, interim order. Yes.
May I be permitted
yes,
to
yes.
place on VC lordship? Lordship, the present petitioner have filed a present application for quashing of order of cognizance dated 15/2/2021 and the entire criminal proceeding. Lordship, while performing official duty, cognizance was taken against the present petitioner. Lordship, Annexure 1 is the cognizance order, Lordship. Page 16, Lordship. Lordship, may kindly have a glance at order dated 15/2/2021. The case record is put up today for necessary order. Peruse the complaint petition, the initial statement of the complainant and the statement of witness examined on behalf of the complainant, initial under section 200 CRPC and 202 CRPC. On perusal of the above mentioned documents, it is found that there is prima facie case made out against the accused persons. The materials on record reveals a prima facie case for commission of an offence punishable under section 294, 323, 427, 447, 506. Hence, the
you are appearing for opposite party number 2.
I'm OP number 1, my lord. Complainant, my lord. My lord, in this case, my lord, without noticing to opposite party, the petitioner along with others demolished my boundary wall. And when I asked about that same, they threatened me and exploded with a filthy language, lordship.
Lordship, may kindly have a glance at Annexure 4, Lordship. I have annexed all the documents, Lordship, with that effect.
Kindly see to page 26.
1 minute. Yes.
Lordship, in the instant case, the opposite party number 2 filed for demarcation. Subsequently, on 5/1, the opposite party number 1 took time. Subsequently, notice was issued on 15. And subsequently, on 22nd, another notice was issued. And it was duly attested by the
all that will be gone into by the courts, permitting the petitioners to raise all pleas at the appropriate.
No sanction order has been obtained in this case.
All that can be argued so late. Yeah. Permitting the petitioner to raise all pleas at the appropriate stage. Yes.
79. 79.
Nana basis.
At number 80.
May I please, your lordship?
Lord, here, Lord, I have challenged, Lord, the order passed by the learned session Judge Khorda, Lord, the page 16, Lord, the annexure 3, Lord, where my vehicle was seized, and Lord, the confiscation problem, the confiscation proceeding, Lord. The revision petition was dismissed, my Lord. The now, Lord,
What were the instructions? You took time for instructions.
Lord,
You had at one stage taken time for instructions.
no, my Lord, the last time, I think, my Lord, the learned council for this.
Whether confiscation
Yes.
authority has seized over the property or not.
My Lord, the government council, my Lord, because my no notice has been issued to me, my Lord.
Yes,
And in the meanwhile, Lord, this honorable court had decided the matter, my Lord, so many cases, my Lord, in respect of the confiscation proceeding.
So you can renew the prayer, sir, then.
No, let's kindly see the.
Ashish Ranjan Mohanty.
My Lord. Yes, my Lord, that is true, my Lord. The notice has been issued to the accused, my Lord. They are not cooperating in the confiscation proceeding, my Lord. Therefore, that is pending.
Notice.
And when
Notice has, my learned senior, my Lord, great respect, my Lord, my learned senior saying notice has been issued, but it was not sought to me, my Lord. For that reason.
Give him a copy right now.
Yes, my Lord. If your Lordship may kindly, my Lordship, I have submitted the judgments, my Lord. This honorable court decided already, my Lord, the respect of the confiscation proceeding. The vehicle was released.
Make another fresh prayer in light of that judgment.
Lordship, I have already given him, Lord.
The petitioner states that
all the decisions
he will withdraw the present petition with liberty to file a fresh application under section 457 CRPC for it to be considered in accordance with law by the, as explained by this court in Ashish Ranjan Mohanty versus State of Odisha 2022 1 OLR 555. If such application is filed afresh, it will be considered independent of the impugned orders in accordance with the aforementioned judgment of this court as expeditiously as possible. The petition is disposed of, his withdrawn liberty is prayed for in the purpose.
Great fellow.
Item 81.
Wait, please, Your Lordships.
I am from the opposite party.
Item 81, Your Lordships. I'm challenging the order of cognizance which has been taken in a protest petition. Your Lordships, the entire allegation revolves around the purchase of a land way back in the year 2002, and the parties are relatives, their brothers. So, Lordships, there's a catalog of judgments by this honorable court. It says that where a civil dispute is been given a color of a criminal dispute, then it should be quashed. I can cite those judgments, Your Lordship. I call it another day.
Yes, ma'am. They took advance in case and check, but they didn't return the same. And
so, how is it a criminal case?
My Lord,
how is it a criminal case, sir?
They cheated this informant, my Lord, by taking advance but not executing the deed what they promised, and all proof are with the informant to for the cheating, my Lord.
307 is also there.
No, Your Lordships. That in the initial FIR, they were, Your Lordship will find it at page 13. Initially, they had lodged a complaint case. After investigation, it was said that there was a mistake of fact. Pursuant to that, a protest petition was filed. And later on, Your Lordship will see the cognizance has been taken. Your Lordship will find the order at page 42. Only under section 417, 420, read with 34 IPC. And Your Lordship will see the even the statements I have annexed. Everything he says that way back in the year 2002, land was purchased in the name of the petition number 2. And that is the entire thrust of the allegation. It's completely civil in nature. And also time bound.
At the request of counsel, the petitioner wants to submit a note of submissions. Let's move for the roster bench. On 1st August, interim order to continue.
Highly obliged.
Item 82.
82, my Lord. Due to ill health, Mr. Tripathi has not come.
What's the matter about?
Can be taken after vacation.
What is the matter about?
I have known.
My Lord, allegation under section 498A and charge sheet has been filed, my Lord.
Oh, it is seen that the court is informed that the charge sheet has already been filed in the matter. Paragraph. In that view of the matter, permitting the petitioners to raise all pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated.
Item 83.
None appears dismissed.
Item 84.
May I please ask? The present petition, my lord, pray for passing proceeding where annexed to 2 on two grounds, my lord. One is, my lord, the police has no power to investigate and register affairs on drugs and cosmetics. The second is, my lord, the same cell allegation, same informant already filed a complaint before the SDM had annexed to 1. And first ground is covered by, my lord, the judgment of Appeals Court, report in AR 2020 SC, page 5274, in case of Union of India versus Ashok Kumar Sharma. And my second ground is covered by, my lord, the judgment of Arnab Ranjan Goswami versus Union of India, my lord. Because multiple reference is not permissible, my lord.
Got it. Permitting the petitioner is all pleas at the appropriate stage. The petition is disposed.
Let's kindly see, my lord. Let's kindly see, my lord.
Charge sheet has been filed.
There is a point of view involved.
Yes,
Let's kindly see, my lord. Gross cosmetic, police have no power to investigate. Let's kindly see the judgment, my lord. After judgment, after
You can point it all outside to the trial.
well, there are two cases pending against me, my lord. In
Correct,
two
correct.
cases, my lord. One in the first case, charge sheet submitted. The second also final period is submitted against me, my lord. I face two cases, but same fellow comes, my lord. Let's kindly see, my lord, judgment, my lord. The clear judgment of Appeals Court, my
You
lord.
can point it out to the trial court, sir.
My lord, how there is no scope for pointed, my lord. Because there are two cases, my lord. In different court, my lord.
All right.
That's two cases in different. Let's kindly see judgment of Ashok Kumar versus my
All
lord.
right. All right.
So there is a clear, my lord, gross cosmetic, police have no power to investigate and register, my lord, the case.
Okay. Okay.
Right. 85.
Interim order is vacated.
That's my dispute merit mail.
No.
Yes. That's my dispute of merit mail. I should approach higher for.
No. It's all
There
right.
is a clear judgment of my lord. Appeals Court is there, my lord.
It's all right. You can raise all pleas, sir.
I've
You can
already
raise all
filed
these
my
pleas.
judgment, my lord. You can see. I've already filed for judgment, my lord. Let's you kindly see the para 150 of my lord judgment, my lord.
Yes.
The clear, let's kindly see, my lord.
Yes.
Page, my lord, 43, my lord.
Yeah.
That's the conclusion partner, page para 150, my lord. Thus, we make conclusion direction 150. Thus, we may call out our conclusion direction as follows. In regard to cognizable offence under chapter 4 of Act, in view of section 32 of Act, also the scheme of the Code of Criminal Procedure, police officer cannot prosecute offender in regard to such offence. Only person in section 32 are entitled to do the same.
You put down both these matters. You say in criminal MC 1295/2021, the following order was passed on 25th November 2022. Set out the whole order. Counsel for the state informs the court that a charge sheet has already been filed in the matter. Paragraph. In that view of the matter, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. That companion matter. You see, in view of the order passed today in 1295/2021, the present petition is also disposed of in the same terms. All right.
Item number 85.
None appears.
May please, Your Lordship. At passing of proceeding on the ground of compromise, my lord, 498 allegation, copy number 2, 10 days appear and file an affidavit, my lord. And
matter has been settled between us, Lordship. I filed the affidavit and also Bhakalatnama.
permanent alimony has also.
All right. Counsel appearing for opposite party number 2 confirms the affidavit filed by her, in which she states that all disputes between the parties have been settled. And even a marriage has been dissolved through mutual consent. That view of the matter takes from prayer clause and all proceedings consequent thereto hereby quashed.
Item 86.
Well, question.
Yes, books.
86.
None appears dismissed.
I am for the opposite party, Your Lordship.
All right. None appears to the petitioner dismissed.
All right. Item number 87.
None appears dismissed.
88.
Let's be 88 liberty may be granted to raise all the pleas.
All right. Permitting the petitioners.
Item 89.
89, my lord, I am appearing through virtual mode, my lord.
This is a case, dispute between two brothers, concerning a boundary wall. In fact, some exaggerated allegations are made, in the FIR. The matter was referred to the mediation, but the opposite party didn't cooperate,
All right.
I am trying for a settlement.
What happens, sir?
No, I am trying for a settlement outside the court, my lord. Your lordship may
Whenever
grant
that
the
happens,
liberty.
you can
Yes,
always
yes,
approach the
my
trial
lord.
court.
That is what I am praying for, my lord. That your
You need not
lordship
keep
may
this
grant the
pending.
liberty.
Yeah, counsel the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies in accordance with law. All right.
Obliged.
Item 90.
Dispose of his withdrawn liberty is pending.
Item 90.
None appears dismissed.
91.
Praying for an adjournment, my lord. Praying for an adjournment due to misplaced file.
No. Counsel
After
the
vacation.
petitioner states that the file has been misplaced. Dismissed for non-prosecution with liberty to file an application for restoration as and when the file is traced. Interim order of case.
Item 92.
Permitted to raise all.
Permitting the petitioner to resolve please.
93.
None appears dismissed.
94.
I am for the OP, my lord.
All right. None appears to the petitioner dismissed for non-prosecution. All right.
Item 95.
May I please? Here, my lord. Challenging the cognizance order under Annexure 2 under section 341, 323, 294, 379, 506 and 34 APC. In fact, my lord, the opposite party number 2 filed 1CC case before the Lord and Lower Court by virtue of 156(3) CRPC. The FIR has been filed because there is dispute between the
one Mr. Jyotirmay Sahu and SK Patnaik are shown
I
to
am for
be
the
appearing.
opposite party.
What do you say?
My lord, may kindly dispose of the matter and may direction be given to raise all the points at the time of coming up charge.
Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. Interim order of case.
Obliged.
96.
May I please, my lord, VC, and shall be permitted to withdraw this application as the cognizance is already taken.
Or dismisses withdrawn.
Item 97.
May I please, Judge? As they were arising out of a matrimonial dispute, the matter has been amicably settled out of the court. Notice has already been issued, but yes.
Who's appearing? No, somebody's filed wakalat for her. Let's see who has filed. No wakalat. All right. Despite service of notice, none is appearing for opposite party number 2. The IIC of Sea Beach Police Station, Puri, will ascertain from opposite party number 2 if the disputes have been settled. A report of the IIC be placed before the court on the next date. List before the roster bench on 23rd June.
98.
98, my lord, your lordship have a glance the order dated 18/1/2023. On that date, my lord, the joint affidavit by the husband and wife was filed. And your lordship was pleased to issue notice to the OP number 3, who is the informant. Now, my lord, they are married and blessed with a female child. They are leading happy conjugal life. I don't know whether notice.
Yes, my lord, notice has been made sufficient.
But nobody's appeared, entered appearance.
Notice has been made sufficient, your lordship.
Nobody's entered appearance.
No.
My lord, IIC has served the notice, man. IIC has served the notice.
Okay. But is it right that the matters have been settled? The matters have been
Yes,
settled?
yes, my lord, they are married. And my lord, they had also appeared before this honorable court on that date.
All right. The affidavit of opposite party
That observation is there.
stating that she and the petitioner have married of their own volition is on record. It is stated that the IIC himself has served the notice on her.
On 31/1/23.
So, since the affidavit is not in dispute, take from the prayer clause and all proceedings consequent thereto hereby quashed.
Item 99.
Your Lordship, I am appearing for the petitioner in item number 99. The Lordship, your offences are under section 417, 493 and 506 of IPC. And the petitioner is on bail. In fact, marriage was solemnized on 2nd December 2020. And just on the eve of marriage, the opposite party number 2 filed a complaint stating that she was having affair with the petitioner since 1.5 years. Your Lordship, there is no tangible evidence at all. And
One
moreover,
Mr.
the
BK,
essence-
1 minute, sir. One Mr. BK Behra -1 and Mr. PK Dash is shown appearing for opposite party number 2. However, none is appearing today on her behalf. The registry will telephonically inform them to remain present at the next date. List on 23rd June before the roster bench.
Item number 100.
None appears dismissed. But I am for the opposite bench. All right. None appears the petitioner dismissal.
There may be pardon to make a mention, my lords. Item number 15, I was on legs on another court, my lords. Item number 15, there's this bail, there's this application for quashing of the 138 enact proceeding, my lords. The petitioner is a senior advocate of this honorable court, my lords. Item 15, my lords.
Yes.
This honorable court, right, order dated 15/9/2021, order number 7, has passed an order directing the petitioner to take steps for publication of notice through local newspaper, my lords. In the meantime, the petitioner is suffering from neurological problems, my lords. That's why he was being shifted to Delhi, my lords. So kindly 1 week time may be granted for fresh notice, my lords, for publication of the notice through the newspaper, my lords. Item number. And day before yesterday, his brother died, even, my lords.
Whose brother?
The petitioner's brother. He is a senior advocate of this honorable court, my lords.
Counsel for the petitioner states that the petitioners suffered a bereavement recently. The publication notice is taken off. Steps have not yet been taken for substituted service on opposite party. As a last chance, the needful be done. For publication of notice through the leading local newspapers. By the matter be placed before the Registrar Judicial for that purpose. On 23rd June 2023. Interim order to continue. List on 4th September for the roster bench.
Obliged, lords.
Item 46.
Yes, my lord, before your lordship starts, in both the items, we have filed an affidavit of the additional chief secretary revenue. So far as the draft policy is concerned, Mr. Dole is there in the item 44. In item 46 also, there are some lawyers agitating this particular issue. That affidavit may kindly be seen.
Right. My lord, before that, my lord directed the member secretary here should appear before my lord. She's in decision, my lord.
Correct. I think we'll come.
Everybody is
Filed on behalf of CA, we have already filed the affidavit through online. These are the offline affidavits.
Let us first see the affidavit of the revenue secretary
Correct.
with regard to this draft policy, because that is most important, which my learned friend Mr. Dole has raised in his writ petitions.
Oh, now the draft policy is being sent to the collectors for their views.
Yes, my lord.
Oh, so this will take some time.
And stakeholders also.
No. Where is the draft policy? That's not here.
No, that's not here because it is not final. Because now we have to seek opinion from the districts and stakeholders. Traditional fishermen.
Stakeholders will include all their clients also.
Yes. Para 5 may kindly be said. And para 6 is also, your lordship may kindly see, before finalizing the policy, consider views of the departments like fishery, animal so-and-so, forest environment so-and-so, law department are to be taken into account. After the finalization of the draft policy, it would be placed before the state cabinet for deliberation and approval. That keeping in view the above things, 6 months time may please be granted for placing the draft policy before the honorable court. This is the prayer before your lordship.
What do you have to say?
In fact, I am appearing for the fisherman. He is appearing for the non-fisherman.
No.
Then you are also fisherman.
Yes, I am for the
Okay. I stand corrected. I stand corrected. Both of us are appearing for the fisherman.
Traditional fishermen.
Traditional fishermen.
They have two categories, professional and traditional.
Correct. It's not, since the state has framed a draft policy and it's more before my lord. City has framed a draft policy and it's before my lords. They seek some time to finalize it. But a reasonable time to be given to them so that they come out with a concrete.
And the procedure we have to adopt, that we have stated in our affidavit. There is a
All right. Just say draft policy of the state government for fishing in Chilika. Then you say an affidavit has been filed by the additional chief secretary of the revenue and disaster management department, government of Orissa. Dated 11th May 2023. Enclosing minutes of a meeting held on 6th May 2023 under the chairmanship of the deponent regarding the procedure to be followed for finalizing the draft comprehensive policy for fishing in Chilika furnished by the Chilika Development Authority, (CDA). Inter alia, the minutes set out the following resolutions. Just take A to A. Mr. D.K. Manthi, learned additional government advocate, states that the expression single quotes different stakeholders would obviously include traditional and professional fishermen, PFCSs, and therefore the clients of some of the counsel who are appearing in these matters, who have also filed intervention applications earlier. Paragraph. The court directs that the finalized policy,
draft policy.
Okay, the approved draft policy.
Yes, draft.
Be placed before the court within a period of 6 months as assured by the government.
Obliged.
Lordship, again, Lordship, one more prayer. And last occasion, I was renewing my prayer, Lordship. In fact, Lordship, they are coming up with a policy. Now, in fact, Lordship, there is no existing policy in Chilka for both fishermen and fishermen. But this is a traditional method, Lordship, to make our livelihood, Lordship. We are fishing inside Chilka. We are not doing any culture. And our duty only to fish inside Chilka. We should not be disturbed. By this process, Lordship, they are not allowing anybody, Lordship. So we should be, the fishermen should allow to fish inside Chilka only, Lordship. That may be clarified, Lordship, because that is again the whole problem.
That is a very disputed issue which my learned friend is raising. Then if he wants any order on this, let him come up with a IA so that I can take it.
I think this problem can be solved. We will left open to the state to take a decision on
decision on that, Lordship. Lordship, they will take. Okay, Lordship. No.
As regards permitting fishing activities in Chilika in the meanwhile, the government of Odisha will take a decision at the local level, no?
Local. District level.
At the district level on a case-by-case basis.
Lordship.
Case by case.
Grateful, Lordship.
Then your Lordship may kindly look to the affidavit of the collector Puri. Let us first see the affidavit. Mr. Burma, please come online. Mr. Burma. Collector.
Sir.
Yes.
Sir, namaste, sir.
Yes.
PDM Puri, on behalf of Collector Puri, Collector sir is on leave.
The collector is on leave, so the ADM is online. And he has also filed this affidavit, in fact, Pradeep Kumar Sahu.
Right.
Sir, I am ADM protocol, I am not Pradeep Kumar Sahu.
Wait. Don't. Everything is going on smoothly. There is a progress in even the re-emergence is being protected. There is so all your Lordship's directions are complied with, and further things we have to see also.
You served a copy on Mr.
Yes,
Agarwal?
Your Lordship, on your Lordship's last order, your Lordship had directed that they should come up with a comprehensive plan to remove the earthen gauges to drones, and library folder will be created to save the drone footage and the progress of criminal cases, and the trial should be indicated. So they have given a comprehensive plan, and it runs to about 30 crores of rupees will be
that cost the government. That what he is saying, that is correct. We have stated in our affidavit what is the expenses to be incurred in case of this drone survey.
Right.
That in earthen gauges
permanently stopped so that the state exchequer doesn't get exploited in. It's a recurrent thing. It has been going on since decades. Unnecessary burden on the state exchequer, all these things. First, you allow it to come and then you remove it. It's
page 5 of my affidavit. Expenditure estimate. Page 5.
Sorry.
Total excavator. 40-60 50% of total will be evicted by labor and 60% by excavator.
They are destroying the prices without method. They have to file the counter in this case. They have not filed the counter. Our intervention is not allowed. So we have filed. Okay.
All right. The additional district magistrate, Shri Pradeep Kumar Sahu, Additional District Magistrate Puri is present in virtual mode. His affidavit dated 11th May 2023 has been produced. Stop. Interior it is stated that satellite footage is now available to enable mapping of these illegally erected earthen gheris. Copies of some of the maps have been enclosed with the affidavit. You are supposed that a library folder of drone footages taken on a daily basis will be preserved in the office of the Deputy Collector Judicial Puri for purposes of effective monitoring. So the details of the affairs registered have also been enclosed. So 122 cases have been registered up till 30th April 2023. And in 108 cases, it is stated that charge sheets have been filed, while 14 others are pending investigation. Paragraph. The details of the eviction processes, the details of the evictions of unauthorized gheris between 10th January and 28th April 2023 have been set out in a separate annexure to the affidavit. It has been assured that there is continuous patrolling of the already demolished illegal prawn gheris, and that helplines have been set up for quick response in the event of their re-emergence. Full stop. Paragraph. The court would like to reiterate that the issue is such that it would require constant vigilance and monitoring without any slackening of frequency or the measures already put in place. Full stop. The affidavit sets out the budget estimates in using both manual and mechanical methods of demolition of the illegal gheris. What about the other three districts? We have
Then we will go to Ganjam. One by one, I will place before you. Then we will go to Ganjam.
My lord, I have one prayer, my lord. My writ petition, that is 23877 of 2021, that is a river. That Doya river that has joined with the Chilka Lake and the fishery sources, because of the bifurcation and reorganization of the district.
Let us finish one district by district, then just wait.
But I have not got any copy.
No, this is district wise we are taking
only
off.
whether it is covered by that policy or not, because since it's a river.
The policy has not come yet.
My lord, in that case, I am for the OP number 13. So that policy not covered in that case, because in the 23877, his policy not recorded in this case because of bifurcation of district. In that case, petitioner encroaches in the other district. These belong to Puri district. I am Dinabandhu. That is exactly the dispute. Yes, in that case, government has filed. In that case, government have also
In
filed.
that case, your lordship may kindly segregate this case, not with this.
No, no, on your prayer it was tagged.
No.
Yes,
If it is tagged, okay, let us finish all these things. We will take up that Dinabandhu case.
Keep it detached.
No.
Let state government file a counter.
No, we have filed counter. My Lord Senior don't know. Tahsildar has already filed counter.
Tahsildar counter will not do because
that court will decide. You have to say that whether that counter will do or not. Your lordship has stayed the auction process. The auction process has already been. They are not allowing us to put your lordship will keep it for a moment. Let us finish all this district wise, then we'll.
I humbly pray, let them file a counter.
I have filed the counter.
No, my lord, because of interim order, they're always taking time for.
Wait karantu, I can wait karantu. Sorry, jo, amore eta last district wise. So let us finish it district wise. Lordship may see the district Ganjam.
Ganjam, yes.
That is the Tahsildar Ganjam. Mr. Parida.
Good afternoon, sir.
Good afternoon.
Please, the collector is here.
The status of criminal cases has been discussed, your lordship.
This is Arun Kumar Naik. He is the Tahsildar Ganjam. He has shown the affidavit.
Right.
They have not filed the reply, sir. State has not filed any
You are
counter
saying
in the case.
ଆଉ ଗୋଟେ କୋଉଥିରେ ଲାଗି ଯାଉଛି ବୋଧେ ନା the photographs are there, my lords.
Dated 8 May 2023. Sworn to by Mr. Arun Kumar Naik. Closing photographs of the demolition of illegal prawn gurries. As well as the re-emerged giri in some areas. Stop. It is stated that an FIR has been lodged on 29 January 2023 against the encroachers. Stop. It is assured that revenue and fisheries officials are regularly patrolling the shoreline of both the Chilika Lake as well as the Palur Canal. Stop. The court expects the said FIRs to be taken to the logical conclusion by completing the investigations and filing the charge sheets. Stop. Then,
if your lordship, no, then we will go to Khurda. But if your lordship wants to see the demolition process, we have videograph. Or your lordship may say that videograph, drone camera we
drone
have.
footages have also been placed on record.
Then your lordship may see the next is Khurda.
Right.
In Khurda district, we have filed two affidavits. One is affidavit of Tahsildar Tangi, another is affidavit of Tahsildar Chilka. Mr. Collector is present online.
So, good afternoon, sir.
Good afternoon, sir. So this para 6 of the affidavit of the Tahsildar Tangi.
Yes, my lord.
He mentions one Ramzan Khan's IA number 13560.
Yes.
So these three aquaculture ponds are falling within 200 meters, is it?
Yes, my lord. That is the affidavit. That it is also ascertained from the further place that three aquaculture ponds in Mauja Jagannathpur of Ramzan Khan.
Who's anyone? So it is within the 200 meter HTL.
No, last occasion it was hard this matter. That my lord, there is my lord, collector's affidavit, my lord's earlier affidavit is flag 125. Flag 125. In the para 5, let's you can listen.
Get the date.
Flag 125. 20th 12 2021. Para 5 of the counter affidavit filed by the collector. In fact, sir, salinity of that area, salinity of the water of that area is not prescribed for shrimp culture. Only they are doing PC culture. Last again it was heard this matter and directed for inquiry, and inquiry report has come, and I specifically argued before this honorable court that 200 meters is applicable to sea, 100 meters is applicable to Chilika. Kindly recollect that. On the basis of CRJ notification, I argued this matter that so far as Chilika is concerned, 100 meters CRJ zone, and sea is concerned, 200 meters CRJ zone. And so far as my ponds are concerned, pisciculture ponds are concerned, beyond 100 meters out.
No, 200, within 200 meters.
Within 200.
Yes, but I am in 100 meters away. My ponds are not within
That
100
is
meters.
beyond 100 meters and within 200 meters.
Within 200, sir.
Yes,
limit
that
is 200.
CRJ is applicable 100 meters.
No.
That is there. You will also kindly see that notification. That mother kindly see flag 95. Flag 95 notification. But government himself has filed that notification. That notification I would find flag 115. Flag 115. CRJ notification. That Annex 9, page 54. May I read that CRJ notification, that portion?
Yes.
CRZ shall apply to the land area between STL, height line, to 100 meters or width of the creek, whichever is less on the landward side along with the tidal influence water bodies that are connected to the sea, and distance up to which development along such tidal influence water bodies to be regulated shall be governed by the distance up to which the tidal effects and experience shall be determined based on salinity concentration 5 parts of the thousands measured during this period of the year, and distance up to which tidal effects and experience shall be clearly identified and demarcated accordingly in the coastal zone management press. But your lordship specifically, your lordship kindly have that specific provision, that page 63. An area up to 200 meters from STL on the landward side in the case of seafront, and 100 meters along tidal influence water bodies or width of the creek, whichever is less to be earmarked as no development zone. That means 100 meters in respect of the lots except sea, and 200 meters only sea.
All right. Anyway,
My lord, your lordship may kindly have a
it is
glance.
stated that 3 aquaculture ponds in Moza, Jagannathpur, stated to belong to the applicant in IE 13560/2021 bracket Ramzan Khan, are falling within 200 meters of the high tide line. So counsel for Shri Ramzan Khan, however, informs the court that as per the CRZ notification, these 3 aquaculture ponds would not fall within 100 meters of the HTL. Full stop.
Who will give specific reply on this?
All right. So Kurda is also over. Kendrapadan.
My lord, may kindly know that we will give specific reply to this.
Your lordship states that we submit a specific reply to the above submission. Supplementary affidavit to be filed before the next date.
Then Kendrapada. Last
My lord, I have first mentioned that contempt petition 393 of 2020.
Yes, that I have received the copy. I will seek instruction from the and what is the real.
My lord, that your losses are specifically directed to maintain the status quo.
Yes, that is a status quo order. The allegation is that there is violation of the
culture, my lord.
No, so Mr. Monty, this is the point.
Yes.
Just to tell you what because you were not there when the court matter was first in the previous hour, prior to lunch. His point is that if you have violated the status quo by setting up the prawn geri, then he has a right to remove it. This is the argument.
My lord, I have not doing any prawn culture in that ponds, 10 ponds, my lord. Now your lordship kindly say, not a single machinery is there, my lord. I obeying this order, status quo order, my lord.
Let them reply.
Yes, we will file.
Not only, my lord, they have demolished the ponds, they have demolished my house. The trees were uprooted, the embankment. They have devastated my farm completely.
We'll ask them to reply, sir.
Lordship, I may be allowed.
CONTC
number 1.
CONTC
Lordship, I may be permitted to. I am in IN number 13647 by 22, Lordship.
Yes.
In this case, what is happened, Lordship? They have demolishing the one pond, which is lying in the private ponds, Lordship, and they are not filing the counter in this case. The collector Khordha, without doing any demarcation about the high tide line and also the coastal regulatory zone, they are going on demolishing the ponds, which is not within their Lordship. Your Lordship have a glance to IN number 13647 by 21, Lordship. Just have a glance to the
every time, Mr. Monty, you take time to file an IA.
Yes, that is
this IA.
That is
they are not filing the Lordship.
That number, please. Kete number
13647 by 21, Lordship. IN number. There are many applicants in this case, Lordship, and they are not filing the counter, and they are going on demolishing the.
I undertake. I will file the counter on the next day at any cost.
Lordship, my prayer. Prawn is just like the vulture in the earth. They are cleaning the Chilka water, Lordship. This has to be legalized. That is my whole prayer, Lordship. In Chilka water, the
policy
prawn
will
culture
come,
is to be
then
legalized.
everything will be set right.
13647 of
in Andhra and Tamil Nadu,
Mr. Mohanty assures that the reply will positively be filed to this IA for the next day. In contempt case number 3393 of 2023 is a notice. Mr. Mohanty accepts notice for the opposite parties and states that he will file a para-based reply before the next date. Then one more affidavit of Kendra.
Yes, there is another affidavit from Kendrapada. That is from Tahsildar, Mahakalpada, Tahsildar.
Rajendra Kumar Acharya.
Yes, my lord. Deputy Collector of Kendrapada.
There's an affidavit dated 12th May 2023 filed by Shri Rajendra Kumar Acharya, Deputy Collector Judicial, Kendrapada Electorate, setting out
that status report is at Annexure O by 12, page 5. Joint verification was
present status of the consideration of the 144 applications. In the meeting of the SDLC held on 8 September 2022, it is stated that 526 fresh applications have also been received.
My lord,
at this stage, I think we can bring in.
Yes, collector is there. Mr. Rudraj.
No, we can also bring in Dr. Kripa.
Yes, the collector of Kendrapada.
Yeah. Dr. Kripa, can you tell us what the present position is?
She is there.
Namaste, sir.
Namaste.
Sir, at CAA, we have processed all the applications sent from the different districts of Orissa. And we have sent which are complete in all aspects, that we have got approved from our authority and sent directly to the farmers with a copy to the DLC.
How many such applications have been processed?
Sir, 929 applications. We have given the table also, sir.
Just now I have filed that affidavit. Just now I have filed those affidavits.
Yes, sir. Yes, sir. So everywhere in all districts we have returned some few applications where we have some doubt. The doubts arise if it is between the 200-meter no development zone, or if it is very near to the or beyond 2 kilometer also. So those we return to the concerned DLC for clarification. But there are some applications which we could not process further though they qualify for registration in all other aspects, except for the fact that they are given as inside Bitarakanika sanctuary. So, as per the CAA Act, if it is within a sanctuary, we cannot give registration. So, but since they qualify for all other criteria, we have written to the collector of Kendrapara to communicate to us whether it is in order, whether the registration can be given. So, if the government of Orissa gives a reply to this query that it does not come under the sanctuary, that it is that registration can be processed, the application can be processed properly with their recommendation, then immediately we will give the registration certificate also, sir. This is the status of applications of farmers from Orissa, sir.
All right. At this stage, must be noted that
Lordship, may I submit,
Secretary of the Coastal Aquaculture Authority (CAA) appeared on time
our
to explain
application is pending for
the contents
consideration
of the
before the Coastal Agriculture Authority.
counter affidavit
Under the collector Khordad, the
dated
CA applications are pending with Lordship.
11th May 2023, handed over in court today. Annexure A to the affidavit are the details of the applications received from the DLCs of Bhadrak, Puri, Baleshwar, Jagatsinghpur, Ganjam, and Kendrapada for fresh registration of coastal aquaculture farms, (CAFs), whereas the details of the applications received from the DLSCs of Bhadrak, Baleshwar, Ganjam, and Kendrapada for renewal of registration of CAFs has been set out at Annexure B. Copies of this affidavit will be provided to counsel appearing for the various interveners. So that
provide
they
their
can
main
respond to
ID
the
also
said
we can
affidavit.
supply this. Yes.
May I suggest one thing to your lordship, subject to your lordship's appreciation. In almost all the cases filed by Mr. Mohanty, so far as Kendrapada district is concerned, his prayer is that there is an eviction notice and he has applied for registration before the CA, so it may not be demolished. And your lordship has protected him that no demolition, but no pisciculture. By
No prawn culture.
Prawn culture. By making that interim order absolute, your lordship may dispose of the case, but subject to availability of the CA permission, the collector will grant him all sorts of permissions or something like that, whatever necessity for prawn culture. There is no meaning in keeping, because unless that registration part is not completed. If that is completed, our collector
will have to correlate these IAs with those applications that have been allowed or considered. See, in this annexure to this affidavit,
there are several independent read petitions filed by Mr. Mohanty.
Someone will have to correlate. Let this copy be given to them, then we can pass that on.
Okay, it's so.
Your Lordship, I have got a submission with regards to Kendrapada, my lord.
Kendrapada interim order in respect of read petition may be extended.
Your Lordship, there are 8 intervener applications. Your Lordship will recall that was appearing in the order dated 15/9/2022, a reiterated letter on 16/1/2023, Lordship. Our applications were not considered, but all but one I have not received any communication.
Today you just get the affidavit of the CAA, you look through it, and then you can make a submission.
All the applications have been recommended by the DLC, my lord. It was for consideration of CAA.
No, so
now CAA has filed an affidavit, my lord. I was hearing that point.
Right.
That some applications they have granted some permission and sought for clarification from DLC, my lord. Let the DLC give the clarification, my lord, on our application if it has not been considered.
All right.
I
See,
think
in the meanwhile,
the
before the next day, the DLC will provide the CAA with the clarifications where available.
Yes,
right.
Without fail.
Yes,
or if any further clarification is required, we'll provide my lord to the DLC.
All right.
Let them seek for it.
Okay. Thank you.
This affidavit we also provided all the information this year.
All right.
The annexes are giving details, data, and everything is there.
An affidavit dated 8 May 2013. Sorry, 10th May 2023 of the Chilika Development Authority of the Additional Chief Executive, Chilika Development Authority (CDA) has also been filed.
The copy of
Three subcommittees have been constituted for hearing the grievance of both the traditional and non-fishermen.
Three subcommittees have been
Yeah, in and around Chilika Lake.
and they have a convened meeting.
On this basis, a draft policy suggestion has been made to the government. Copy of the report for formulating a leasing policy for Chilika Lake is stated to have been submitted to the competent authority of the government of Orissa. Paragraph. Mr. Agarwal, anything more to be done?
Yes, Your Lordship, the aspect relating to pollution, Your Lordship's order dated 15 September 2022 at para 11, Your Lordship had directed the additional government advocate that they will hold consultative meetings with the State Pollution Control Board, BMC, and the Resident Welfare Association, that how the pollution of that Gangwa Nala can be sorted out, because that is the most polluted river of Odisha, which ultimately drains into Chilika. So that they have not yet responded to that. So, no, the learned AGA was directed on 15/9/2020 to para 11 of the order.
15/9/2022.
Yeah, I remember the pollution in the I think Daya River, right?
Daya
Yes,
River.
yes. That Gangwa Nala, which ultimately drains into Daya River and Chilika.
Who's appearing?
Yes,
State Pollution Control Board.
As far as I know, there was supposed to be a meeting under the chairmanship of the, I think, secretary.
You apprise us, sir. The State Pollution Control Board is directed to file a separate affidavit on the issue of pollution of the Daya River and the Gangwa Nala.
There was
Gangwa Nala.
I think earlier there was direction. There was supposed to be.
But you have to file an affidavit as to the outcome of the meetings. The affidavit will explain the outcome of the meetings supposed to have been held by the SCPB,
SPCB,
with the resident welfare associations, which are stated to have been discharging untreated effluents into the above water bodies.
Also with BMC, the meeting.
That SPCB is the nodal agency. They let them organize all these things. All government agencies will cooperate.
Let CA affidavit may be provided. Copy of the CA affidavit provided.
My lord. 3rd August.
3rd August, my lord.
Both the items, Lordship, 44 and 46.
Both 44 and 46.
Yeah.
My lord, may see 23877 of 2021, where Mr. Mohanty was appearing for the petitioner. Senior, let us. I pray your lordship to take up that matter. That is independent of all these.
What I beg to submit, your lordship, kindly see, my lord, page 33. The writ petition. Well, this writ petition was amended and that is consolidated is filed on 30/11/2022. Thereafter, no counter has been filed.
In
I have not been given any.
My lord, we have filed counter affidavit. It is not up to the petitioner to say that who will file the affidavit. Your lordship may see in within.
But copy may be given to us.
That copy has already been given to the lawyer who was appearing before your appearance. Today you might have appeared, I don't know, because somebody, other senior advocate was appearing.
Earlier I have appeared. And
No, Mr. S.D. Das. Mr. S.D. Das was appearing.
But
I have given I can show the receipt.
Amendment
On that line, you should not take the adjournment.
Kindly see counter.
We have filed the counter, we have served the copy.
But when the counter was filed, lordship, kindly see. That is, and kindly.
No, after amendment, we will not file any counter. So,
then all right, will not do.
Yes, let us hear let us.
First May you have filed.
Yes,
recently. Let him examine it, sir. You give him a copy.
My lord,
if you
I have given the copy. I have given the copy.
Give him another copy. It's only 1st May. We are not even on 10th May now.
My lord,
May,
yes, I will give. My lord, there is nothing to be. But what is my anxiety is that.
No, if he cannot tell you whose affidavit should be filed.
Right.
If you say this is the affidavit, let him proceed on that.
I will, but
So at least I can file a rejoinder to that, then your lordship can hear the matter, my lord. Only that much.
kindly see what is the fact. Just quickly I will place before your lordship.
But honestly saying that since this matter was tagged with all these matters, so I was just to pray your lordship, it should be segregated.
All right.
I was
That
not
is also
prepared
agreed.
for this.
Yes, on the reopening date.
My lord, my submission that prior to filing of counter by the state, I am representing for OP number 13. I have given my written note of submission in this case along with the document of the state, my lord. The case is that the person who has no locus standi filed this case.
A frivolous case, totally.
And
we have already completed the auction process. Then they have obtained
that's
a
why 700 people of villagers Nagar living starving, my lord.
Let him participate in this auction. They say that you forcibly, they are forcing the state government that this Hoiraxor should be settled in our favor. How can it be? This is against the guideline of the Honorable Apex Court.
Because
we have to put it to auction. And auction process has already been started.
No, we are not standing on that way.
They are taking
that
time.
may be recorded. Your lordship may record the statement of my learned senior.
Kindly allow me to submit.
Time and again they are taking time because of different reason, my lord.
No, we
So because of interim order, my
are
lord.
not taking time.
They have given protection. That's why they are taking
Give us
time.
copy. You give us copy so that we can reply to that.
I have already given this copy. What document has been submitted by the state, my lord.
All right.
Everything has. It is aerial.
7 of 2021. A counter affidavit has been filed by the Tahsildar,
Tangi,
District Khorda. In reply to the writ petition, copy thereof be served on Mr. P.K. Manthili, senior counsel appearing for the petitioner in the next 2 days. Stop. Copy thereof also be served on counsel appearing for?
No, my lord. I have not recovered. The document is with me, my lord.
Petition I am appearing. That is one
respondent in this.
13, my lord. Respondent 13, my lord.
Counsel appearing for respondent 13 states that he has filed a compilation.
Yes, my lord.
Copy of which will be provided to both Mr. Manthi and counsel for the petitioner.
Already given, my lord.
Just give him another copy, sir.
Yes, sir.
Lordship, in two of the writ application which I have filed, they have not filed the counter, Lordship. That is 13647 by 22, Lordship.
That is IA. That is IA, not that.
No,
In
Lordship,
that
that is the writ
46.
petition. That is the writ petition. 13647 by 22, Lordship. That is the writ petition. The collector Khordha has not filed any counter in that. 136.
Acha, 13647.
By 22, Lordship.
Right. 13647 of 22. Last opportunity to the state to file a reply to this writ petition. Within 6 weeks, it's joined up for the next date. List on the same day, 3rd August.
Obliged, Lordship.
This separate writ petition that Dinabandhu Das.
Dinabandhu Das. Also, may fix it to run the reopening date.
23877.
Gadi Brahma Private Facility.
Dinabandhu Das is the petitioner.
There is an amended matter in which we said Tahsildar has filed an affidavit. List for hearing on. August.
My lord, this is a stay order is there. So we are unable to proceed with the auction process. So lordship may list in the first week of July at least.
All right. 13 July.
And 13647, what Mr. Biswala was submitting, Sanatan Balwant Rai, we have already filed the counter affidavit.
Lordship, they have not served the copy on me.
Okay, we will serve it again. Okay. In Sanatan Balwant Rai case, we'll serve the copy.
13647 by 22.
Okay. Right.